Yeah. Nothing you.
Oh, mention your name.
Yes.
May speaking lordship permission, Balada. Item number 53. Balada, I found for the record, a service report is awaited for all the usual process and registered force. So Balada, yeah, can it come after 53? I have for the petition number. Service report awaited in both usual process and registered force.
As Mr. P.K. Rachodi, counsel for the petition, submits that as per office note, the service report is awaited. So accordingly, matter stands adjourned today. Interim order past release stands extended till the next date of listing. List after 2 weeks.
Because because yesterday, due to paucity of time, I could not be listed, but the matter was for hearing. And I'm for the other side. The interim order is continuing.
Okay.
May I pray
Give a date.
on 8th?
They will adjust and give a date. Give it to the court master, they will adjust and give a date.
So I'm praying for listing of a matter on 11th.
11th is not coming because it's Thursday.
10th,
Give it to the court master, they will make some adjustments.
may I please announce? So, sir, that you mentioned on MSc appeal, my lord. First, listed wrong back, my lord, and for admission.
Give it to the court master, they will make some adjustments.
Online.
We don't know. Let him take the dates.
Consider the other side. I beg to mention I did 37 Lordship.
37.
File an affidavit in opposition.
37. Yes.
Lordship, I seek 3 weeks time for an affidavit, Lordship.
3 weeks time. Okay. You are there. Okay. Both sides are represented. On the prayer made by Ms. Harbarwa, counsel for the respondent, matter stands adjourned today to enable her to file affidavit in opposition in the matter. Interim order past release stands extended till the next listing. List after 3 weeks.
Pray that the date.
After 3 weeks. Okay. We'll give a date.
I'm praying for listing of an arbitration period sometime in February.
Great.
Please, my lord. My lord, I'm praying for listing of an FAO. Can it be listed on Monday? We are actually challenging the injunction order which has been passed. If possible, my lord, on Monday.
Not on Monday, Friday. Not on Monday. There's some difficulty on Monday. Make Friday.
Always.
Sir, Lordship, I'm praying for this. Lordship, next week, I think.
Due to the court master, they'll have to make some adjustments.
After mention item number 56 of the supplementary.
Item
6 of the
56.
supplementary. Lordship, inadvertently, the impugn order could not be enclosed in the FO copy. Lordship, your FO will kindly allow us to rectify the oversight, and the matter may be taken at the
Okay.
outline.
The learned counsel, the prayer made by learned counsel for the appellant. She is permitted to annex the impugn order in the memo of appeal. So the same may be done in the presence of the concerned section. Thereafter listing the admission column.
Item number 41 for
41.
1
14.
after 1.
You've taken consent of the other side?
No, my senior will inform them.
No question of information. Correct. You're young people coming in the profession. Please try to understand.
My senior
You just think of yourself sitting in the courtroom till 4 o'clock, and then you come to know that your matter is adjourned. Will you like it? Same thing this side also. Renew the prayer when the matter reaches. Yes,
Material. That's what I mentioned item number 28.
28.
I'm for the response.
Okay. Both sides are represented on the prayer made by counsel for the petitioner. Matter stands adjourned today. List after.
Convenient day. It's on the
No, for me, every day is convenient.
2 weeks.
Otherwise, with a smiling face, I would not have come here. Now tell us a date
2 weeks.
after 2 weeks. Give a date after 2 weeks.
I did. Most of it.
Yes.
Daily list item 1.
This matter, the bail application was 39 applications. The petitioner is behind the bar for about 740 days. Lordship, all the other two accused have already been granted bail by this honorable court. And your lordship has earlier rejected on about an year back. It is on 1/3/2023.
Okay. Will issue notice returnable on Friday or huh?
I'll be out of station for
will be out of station?
18 or 19. In the meantime.
19 then.
I
Okay.
know.
Okay. But Mr. Y.S. Manat, counsel for the petitioner. And Mr. S.C. Kyalan is standing counsel for the
Dear,
DRI. Next, Manat. Issue notice of this bail application returnable on 19/1/2024. Post of objection, if any, be filed at least 1 day prior to the date of listing. What do you call? You have everything here. We don't need that scan copies.
basically, I'm basically challenging the part of prolonged incarceration.
Okay.
These are judgments are.
Okay.
It's very recently passed. This, not it's. But-
Item 2.
My lord, it was not given, it was granted us 2 weeks time to file substitution petition, and there were 2 other, my lord, making application for possible amendment, and for my lord, for correlation of filing of amendment. Therefore, we have already informed, we have prepared 3 IAM. We are waiting for my client, my lord, they're coming 13 or 14. Most of the picture immediately after view vacation.
Okay. On the prayer made by Mr. FKR Ahmed, counsel for the appellant, that appropriate application could not be filed for substitution. The matter stands adjourned today. List on 22/1/2024. This item 3. First point may not be so fatal after 2009. Out of 41 rule 31, we'll have to exempt it.
Conclusion of the party was not dependent was according to the plaintiff. The both are sister. Connected.
They are family members, but then if they are family members, why this permissive occupier, that issue will never arise.
also not identical, she is also entitled to possession. But my lord, the land, they allege that they purchased the husband of the defendant. My lord. He purchased the land from the auction purchaser. Land put in the auction, my lord, revenue sale. On Mondal purchased the land. Subsequently, the brother purchased the land. So they claim that it is our own property. It is not the ancestral property. Sister said that no. Since the auction, date of auction purchaser, the auction purchaser never took the possession. All along, she and her father possessing the land. So adverse position claim is there. And the house is constructed by the father as per our allegation. And there is a dispute between the son and father. So he left the ancestral property, deciding along with his wife in separate place. That is why this land was there is a will by the father about two sisters, two daughters. And the mother also,
But that was never probated.
yes, is also here. Probate case is also there. Two probate
Probate is separately.
cases.
But here, is it there in evidence about probate? If it's there, I have missed it.
This particular land is not.
It was granted in respect of the land only.
No, no. Is it a part of this evidence here? Because I have missed it if it is there.
It's a next case, below.
No, but not in this.
This
appeal.
Here is the item number 4, maybe. This is also tagged with this.
Because here there is a issue number 2. If because if the land is covered by a probate, then perhaps the question of right title interest will not.
This particular land, just a minute.
Oh, adjacent land. Okay, okay, okay. No, I just thought because if I have missed it, that means I was reading it wrong.
The ancestral land.
Just a moment. I started from the substantive question of law. I'm not gone to facts. You'll have to come back to facts. Yes.
There are 5 substantive questions.
Yes.
But originally the tag number of the state land of 298, there were 4 brothers. And out of 4 brothers, the eastern part, that is original tag number 298, it is all in the share of father the plaintiff appealant. the next western side land, since the diagram number 391, it is only the share of Puri Soma, Purikanta Soma. And thereafter, question of the Horizontal Soma, Purikanta Soma. So our concern will be 391. That number 391. And in that fact, my lords, land measuring 1/17.5 lakhs.
Yes.
In 20 claim, the said land has a burst position. Although it is only the share of only for horizontal soma, but we do not possess this land. So since the partition made, the land was possessed by the father of the plaintiff. And during the possession method, their land was put into auction sale.
But in the plain, there is no schedule given. It only says DAG number 1391, pata number 391.
This particular that
Okay.
is not that there is a dispute. Defendant claim that this land is purchased by her husband by auction purchase from auction purchase. And auction purchase are purchased the land by government auction method in 1976.
Just a moment. Yes.
Some date may be recorded, my lord. How continue the report, my lord. Hello, the other of the 20 died in the year 1995. That may be recorded.
95.
95.
You have a date? No.
Date is here, my lord. Here is.
Here is relevant. Okay.
And mother died in 1996.
Father of defendant.
Father of defendant plaintiff.
Plaintiff. Mother died when?
1996. And my lord, husband of the defendant number 1 died 17/5/1990.
What is the date?
My lord, 17/5/1990.
Just tell me one thing. This probate was filed by the respondent. Who filed the probate case?
Probate is filed by this plaintiff, my lord,
Okay.
in respect of the ancestral property. And one property, filed by the other system, my lord. She also party in the.
Okay. And this suit was first or this probate was first?
Probate was first.
Probate was first. Okay.
Because their claim is that they objected the probate, my lord. Therefore, we.
Therefore, you file a suit.
Under the-
Okay. Ah.
Land, the particular land for the probate case and the titles are different.
Okay.
So, my lord, in the suit, my lord, suit was dismissed. And their counterclaim was allowed. In appeal also, that was allowed. Now, even if suppose my lord, we admitted that our advertisement is wrong. But title with the single point. The title of the defendant 1 and 2 is not correct, my lord. Because, my lord, the time of date of the noni property, that is the husband of the plaintiff in 1990. The legal heirs and successor are not only defendant, wife and daughter, also mother may. That was not considered anything, right? At the time of declaring the rightable interest of the defendant. After the date of murder, my lord, that is 1995. 1996, my lord. Her share inherited from her deceased son, my lord. That will again divided by the 3 part.
By 3 persons.
The daughter of, that is granddaughter of wife of Ramakant, my lord. declaration in favor of the defendant number 1 and 2, entire line is not correct. There is no.
No, but there will be a fundamental different, what you call, difference here. You see, if you are claiming as a legatee, then question of adverse possession will never come. Your prayer is for extinction of title of the defendant. That will never come, because once you take that plea, that means,
And not of the defendant. And not of the defendant.
no, you look at your prayer in the plaint. I think first prayer is extinction of title of the defendant. Second prayer is claim of plaintiff as a title holder of the land. So once you,
First position. Adverse position.
no, whatever be, but you look at the first prayer.
Yes.
Once you make that prayer, that means you are not asserting your right as a legatee. Because once it is a property which is devolved on all the legal heirs, then one will have position, beneficial position for the others. Therefore, you see the follow-up.
I'm saying that suppose I am leaving that part. There's two parts. One is declared.
No, in second appeal, you can't take that plea again.
No, my lord, there is a counterclaim. This is separate suit.
I understand, but
Separate suit. In separate suit, my lord, this is deciding separate suit. Right taken, interest and position must be proved by the defendant, that is plaintiff. In the counterclaim, he is treated as plaintiff. So, we should establish the title, my lord.
no, you see, that's what I am asking you. Because in my view, what happens is that when you take a plea of extinction of title, then your claim as a legatee will not stand, because you see, if you are legatee, then the principle is that one, you become a co-owner then.
Yes. Part of the,
Yes,
part of the land.
you're part of the land. So once you become a co-owner, then possession of X is possession of Y also. The plea of adverse possession will not come.
Because they claim,
Unless you can show that there was a partition, and after partition, the share was not taken away, then adverse possession will start.
year 1976, the auction purchased the land. So since then, that date, we are possessing, he never come to possess the land. There is not a single word regarding his possession.
Yes, it is there. That's what I checked, because I forgot earlier. You see, in the sale deed, it is given that the vendor has been, the purchaser has been put into possession. Auction purchaser, not auction purchaser, the vendor.
His vendor is not in possession, since 1976.
No, but I don't know. You see,
There is no evidence, because they are writing in the.
no, writing in the sale deed means that we'll have to see the cross-examination. In the cross-examination,
Regarding his position, his vendor position, since in the city. Even in mutation was in 89. Mutation was in 89.
It was bought from the auction purchaser.
Maybe.
no.
On
He's,
24/1,
no. You see, no. This is something, you see, what happens is that this is something we have experience. What happens is that bank takes over what you call possession under the Securitization Act. They say it's a possession which is symbolic. Then they put it into auction saying that as is where is basis. Then somebody purchases it and the vendor says that no, the defaulter says that no, you can't take possession. You see, if you turn back, you will find one gentleman lawyer smiling. If you turn back, no, not that. I'm just saying that if you turn back, you will find one lawyer smiling. Because this is something we have experienced. And therefore, when somebody says that auction purchaser, you see, on an auction, in an auction purchase, what is required is that the Nazir will give a report saying that the purchaser has been put into possession. That evidence, I think, is not there.
Again, thereafter, my lord, if your lordship may kindly turn to page 31.
Huh.
of
No,
your
I'll come back to you. I'm
lordship's
just putting that query to Mr. Dega. But once you take that plea,
I think that submission regarding their package, regarding as a counterclaim. As a counterclaim.
I think that to be.
They have not produced any document regarding the option sale. There will be a procedure after option sale.
No, no, you see, that is not a part of this of the substantive question of at best at 4, question number 4 is whether both the court below committed error in declaring title of the suit line in favor of the defendant respondent, the counterclaim arising out of so and so in absence of positive evidence in support of their title. So that is the question. So therefore, I am saying once you admit title and claim that you are a legatee and you should have got a share, this substantive question of law number 4 fails.
That is regarding counterclaim is there, madam.
No, I don't know. You see, I'm not segregating counterclaim right now. I'm only reading this substantive question number 4, and then saying once you take the plea of being a legal heir of the person.
I am reading again, madam,
Huh.
whether the court below committed an error of law in deciding title of the suit line in favor of the defendant, respondent in a counterclaim, arising the title suit number so and so, in absence of positive evidence in support of their title. So this particular point regarding the counterclaim, madam. it's a
No,
legal-
whatever be, you see, once you say regarding title, you are disputing the title first, whether the counterclaim or suit. For time being, we just leave that one part. When it's a question, second appellate question on title, and then in respect of that title, you say that I am one of the legatee and my share would be there. That means you are admitting title. Once you admit title,
not claiming. I am not claiming my that I am for adverse position. I am possessing the land. I am possessing the land. That case, man, I am not claiming an error success on it. I am not claiming. I am claiming that the land by our adverse position. Even if, suppose, that is payment. So my right of inheritance cannot be extinguished because declaration cannot be made in favor of defendant.
unless you take that plea in the suit or in the defense, in the written statement to the counterclaim, to accept that plea,
Definitely, my lord, if there is a legalization successor, without, my lord, their share is protected, my lord, how can be declaration? Because her husband purchased, their case is their husband purchased by auction purchase, from the auction purchase.
No, no, my lord. It was bought from
No,
him.
no,
Auction
just a
purchase
second.
was made by.
No, you just make a note.
I'll come.
He's famous for long submissions. You just take a note and then address when he comes later.
Her husband purchased the land from the auction purchase. So they say that, so he is the title holder, madam. From his.
No,
title-
you are saying in your plaint that the auction he purchased it from the auction purchaser,
position.
but since there was no position, the mutation was fraudulent. That's what you are saying.
Yes. That is our case, and it is treated as adverse position, madam, because it is factually, that is the position, madam. I was in position, madam, in continuing position. The plaintiff. Now, let's see, no more now, my lord, that sister come in our place. So, my lord, even if we fail that plea, my lord, then our title to our mother cannot be extinguished. So when son died, my lord, as per Hindi Succession Act, class 1 successor are son, daughter, wife, and mother.
Where is the memo? Is that memo of auction purchase? What do you call that?
That is I am saying, my lord. See, they have not produced. No, neither auction, their confirmation must be there, my lord, as far that way, after 60 days confirmation. That is not there, this is paper transaction. And the land was uncle's land, my lord, purchased by third person, then again the cousin passes the land. But possession is not there. Because they are living separately due to the intercaste marriage, and there is a evidence that there is a dispute regarding family intercaste marriage.
Okay, we go through the evidence. The subsequent purchaser was the husband, Nani Chakravarti. But this mutation was there in his name.
Yes, ma'am. In 89, ma'am. 89. 89, he immediately did it. Thereafter, before the suit made up, they have had an unsuccessful mutation there.
The sale deed is of which year?
1976.
Sale deed of 1976.
Let me see. Some person is writing. I'm sorry, Miller. So some person is writing.
Sale deed is 24/1/1984, my lord.
Sale by auction is 1986.
1976.
76. And sale deed is
24/1/1984, my lord.
20.
4/1/1984, my lord.
Mr. Dekha, you are carrying Transfer Property Act?
Yes.
Huh. This interpretation clause, section 3. You will come to after actionable claim, you will find a person is said to have notice? Third or fourth?
Personal claim means a claim.
After that, a person is said to have notice.
Person is said to have noticed the fact when he actually knows that fact or when, but to absence from an inquiry or search which he ought to have made or gross negligence, he would have known it.
Explanation 1.
When any transaction relating to involved property is required by law to be and has been affected by registered instrument, any person acquiring such property or any part of or share of interest in such property shall be deemed to have notice of such instrument as from the date of registration. For where the property is not at all situated in one sub-district, or where the registered instrument has been registered under Registration Act from the earlier date on which any memorandum of such registration instrument has been filed by any services in whose district any part of property which is being acquired or of property wherein the share or interest being acquired is situated.
So third line of this explanation 1, you'll find any person acquiring such property or any part thereof or share or interest in. So once you say that you are a shareholder of, you claim as a sharer of your, through your mother inherits the share of the deceased son. From the son, one share goes to the mother, and from mother, she's a class 1 heir. On her death, you acquire a share.
The second line of argument. The second line of argument regarding counterclaim. The counterclaim cannot declare the title of the whole property to be defendant number 1 and 2. Because legally, and sexually legally, mother is there, cannot be sued, mother inherits the property of this one part. So that is the plaintiff, original plaintiff, the inheritor after mother's death. The mother is there. The mother shares.
That's what I'm asking you. You see, that's what I'm asking you. You once you say that you are claiming title,
The title, I am saying that
title, you see, title as a title, so far as title is concerned, your prayer is in the plaint.
the basis of position. The basis of position, adverse position, what is there, my lord, but court said that it is not adverse position, there is no.
No, there's something else I'm asking. You see, by virtue of explanation 4 to section 11 and order 2 rule 2, all the prayers of the suit must be made in the plaint. If you are claiming by way of inheritance, it should be first claimed in the plaint. And if it is not there in the plaint, then when a counterclaim is made, there you can only take a defense. It's not a plea which is to be what you call. It's not a issue where any relief to you can be given. So now in the plaint, if that prayer is not there, can a defense be an acceptable defense when you have relinquished that claim and you are prevented from raising it under explanation 4 to section 11 read with order 2 rule 2?
My plaint, in that adverse position. Whoever may be the anomaly.
No, exactly, that is the point. You see, you may have 4 derivatives of title. Let us say not 2, we'll give you 4. There are 4 derivatives of title. You get title through line 1, 2, 3, and 4. Now in the plaint, you assert only 1. 3 you leave out.
Yes.
So can you take that plea as a defense in the counterclaim and to what you call to alienate the title of the defendant? That is the question. You see, that's why I'm saying order 4 explanation 4 to rule section 11, which says that a plea taken, the plea which is not taken is also constructive res judicata. A plea which ought to have been taken and not taken would act as an res judicata. Second is order 3 rule 3, all the prayers must be made in one plaint. That is the second part. So if these two are taken together, and if I take this example of 4 line of inheritance, and you take only 1 in the suit, and 3 you leave out, can it be permitted to be taken as a defense? Answer would be yes, because even contradictory plea it can be taken in a written statement, correct? But can it be sufficient to extinguish title when that issue will not be there in the plaint? And in the written statement, extinguishing of title, because you see, question of when you claim adverse position, and you leave out that plea, can it be available to you later on?
First question, I claim on the basis of position. Position I affected to title because but just is the market. But subsequently the counter claim. They claim entire property by the dependent number 1 and 2.
Right.
They claim on the basis of heirs and successor title on their husband. Whether dependent number 1 and 2 can get the title the entire property. When other heirs are there.
Answer is already there.
Other
You-
heirs are there.
Answer is already there. You will show you. This come to page 15 of your memo appeal. Is issue number 3, whether the plaintiff is entitled to declaration of right title interest. Correct. Now this 3 and 4 is answered at page 22. Yes. So that means no evidence is discussed. That means we are presuming that there is no evidence on your part to claim this. That's why issue number 3 decided at page 22. Now come to the appellate judgment. In the appellate judgment, this
It starts.
huh?
Paragraph 15, page 36, it starts.
36. Okay.
Page 36,
Ah.
paragraph 15. My lord.
You see here, 14 is same thing which I'm referring to.
My lord, my claim of adversity is denied by the court. Their plea, that is their plea was accepted, that permissive occupier. They claim that I am permissive occupier. My claim was not recognized by the court. So their plea is recognized that I am permissive occupier. How I can be permissive occupier? Definitely by transaction. If the possession is permissive and not indigenous to the owner, it cannot ripen into title. Title by mere possession or alone. Position is clear, Melo. Position is not disputed. My position is not disputed. It cannot ripen into title by mere possession of house over long. Adverse possession must commence in wrong and must be maintained against right. In the reported case of so and so, I could help. It is well settled that a person or party who claim adverse possession must commence with the wrongful disposition of the rightful owner at some particular point of time, and it should be hostile possession under claim of color of title. Actual, open, notorious, exclusive, and continuous for the required period of time, giving indivisible right of possession or ownership to the possession by operation of the limitations of the action. In the case of some bone number so and so, it was observed that the owner's possession can be resumed to be adverse to the owners only when there is a complete ouster of the other. To consider the adverse position by co-owner outside of the non-possessing share has to be made up. There must be evidence of open assertion of hostile title coupled with the exclusive possession and enjoyment by one of them to the knowledge of the others. And the plaintiff being sister of predecessor of defendant was residing with him and their father. It is a general principle that members of a family may not acquire adverse possession against each other in the absence of a showing of a clear, positive, and continuous disclaimer of the title and assertion of the adverse right against the true owner over sufficient length of time to bar them from the statute of limitation. So here made up the owner. After the purchasing from the some person, he is not claiming this joint property. The wife is not claiming that it is joint property. He claims own property. So the owner cannot be claiming the plea of adverse possession. Is not here in this case.
You see, if I can give one of the horrible examples I can give, it will make things very clear. You see, let us say A is the owner of a land. He allows B, his nephew, to stay there for his education. During that period, when the nephew is staying in that house, other family members are also there. Now, for some reason, this land has gone for a revenue sale. Somebody has purchased it. And then this one of the family members have repurchased that from the auction owner, auction holder. Now this nephew is staying there. Now the actual owner who becomes the title holder, he says, okay, you are a family member, you are a nephew, remain there. And he continues to be there. Now, this judgment which you have just read says that there should be a beginning of a hostile position. Now, when is the date when this hostile position is claimed and asserted?
Yeah.
Because it's not there in the plaint. That's why I'm finding it very difficult to accept your argument. Because if you claim that this date of commencement of position has to be said, mere fact that the position is there. That's why I'm giving one of these horrible examples. His nephew is staying in the house. He is otherwise no right to be there.
Position is not hands of my lord, the husband of the defendant.
Then who is purchasing it? Who's holding it?
We are holding it.
You see, earlier also you were not the title holder.
Not title.
So against that owner also you should in a case of hostile position, you have the principle of tacking applies.
That person, they claim that we have purchased from them.
No, that's okay. But you see, in a hostile position, the plea of tacking applies. 53 or something, principle of tacking, that applies. If your position is hostile with the vendor, and you continue that hostile position irrespective of the vendor being selling the land, your principle of tacking will add that part.
My title, my father, the life of my father. This is the adjacent, the same residence, the adjacent plot. The adjacent plot was purchased. That is in the share of Uncle Miller. That was purchased by the husband of the defendant. So prior to auction Miller.
Yes, I know that it happens in my house also. You see, in my house, it was my father's house. Correct. My father gave me a room, and that room was exclusive to me only. Nobody entered that room. Exclusive possession. Nobody, even if my mother wants to go in, I would shout, no, don't disturb my room. Let it remain as it is. So I claim I asserted my possession over that room till now.
Because there is auction process. He never took the position.
No, leave it as it is.
So in proving their case,
No, you see, that's why I'm asking, giving you that example of tagging. You see, once that applies,
My lord,
just a moment.
But,
You see-
can it be permitted for 2 minutes.
No,
There's a
definitely, definitely.
Item of clothing. which is-
Definitely. Dasji. This is a very recent judgment of our court, because right now this provision immediately that tagging, it was not 53, I was wrong. Just immediately I can't recollect. You see, this is the observation. There's a highlighted last 3 lines. In an adverse position, tagging means position of the previous under the previous owner.
Position is to be on behalf of the owner. The casual user does not constitute a first position. Even the owner can take position from a trespasser at any point of time. It is also well studied that first position is eligible and there can be taking of adverse position by 2 or more persons if the right is transmissible one.
So you see what happens is that we take an example. A is in hostile position. He's been able to assert his hostile position against the true owner. Now this position is transferred to B. B will be permitted to have a tagging. Correct. So therefore, here you see the position doesn't change. There's no 2 vendors, no 2 persons in that. One person, that is you are claiming adverse position against this against the plaintiff. Correct. That means number 1, your previous hostile position against the original owner was never established. Then comes the auction purchaser. You say that auction purchaser was never in position. Therefore, still you don't claim adverse position against him. There's no reason to have a hostile title when the person is not even asserted his position. So number 2, the auction purchasers also hostile position of yours could not be proved. And then comes the third one, which is the respondent. The respondent now purchases the land. How can that hostile position start from here on which date? You have not treated that in your plaint.
People are not here, but on cases that we are possessing it. If we are possessing, that is admitted. That is admitted because, there is no evidence regarding taking possession by the auction person in 76. No evidence. How he possessed the land. When he entered the house, there is a house also. Extended area of the house. He never took the possession.
I'll not be able to follow you. You see, this reason is simple. Once you claim hostile position, then only the burden would shift on the onus would shift on the after you prove it. Hostile position, the beginning of the hostile position, then the onus will shift on the plaintiff and to show that how he got the position. Because you take that plea of hostile position, it is not the burden of the plaintiff in the first place. It will be only on us after you establish that burden.
Now come to the contract line below. Contract line below. Contract line, there is two sections below in the limitation. For position below 64.
Yes,
Article 64.
64.
For position of involved property based on previous position and not on title, when the plaintiff while in possession of the property has been dispossessed to a various manner. So if I cannot prove that my case is gone mad, I think that now come to the their case. Their case.
Just hold.
Yes.
Yeah, just hold. Yes.
Article 65. They have paid for recovery possession limit on the basis of title deed. For possession of immovable property or any interest thereon based on title, 12 years. So, when the possession of the defendant became adverse to the plaintiff, so 12 years. So we are saying that we are in possession. There is a hostile relation between the family relation. They are residing outside during the lifetime of father.
This is a suit of 1985
Yes.
and auction sale deed is of 1984. So 12 years has not gone by. Article 65 will not have no application.
Because we are saying that prior to the auction procedure, we are possessing it.
That's what I'm asking you. I am aware of it. That's what I'm asking you. You see, I have told you three situations. First is the original uncle, who was the owner of the land. There is nothing to show that you claimed hostile title against him.
He possessing separate land.
No, that's okay. But that hostile title, I'm on title. I'm not on the plot of land. It may be A, B, C, whatever. Whatever you are claiming for that uncle is your uncle, you have not claimed hostile.
No,
The beginning of hostile position is not there. Number two is the what you call auction purchaser. Against auction purchaser also you never asserted hostile title because of the fact that according to you he was never in possession. So situation never arose to claim hostile title against him. And if you and this is where I was referring to that section 3 of the Transfer of Property Act. You claim to be the owner or shareholder, and therefore being an owner, therefore you will have notice of whatever has happened in that land. If the land has gone for auction, you are the owner of the land, a sharer of the land, and therefore you have a deemed notice of what has happened. But you don't assert that title. Again, hostile title was not asserted. Then comes your hostile title against number 3, that is Ms. Sharma. Here there must be a beginning date of hostile title. In 84, when the sale was made, you never asserted that hostile title. Therefore, you fail in every count.
My lord, in 76, there are some purchases or there are the G purchase there.
No, that is okay.
We never give up the position. Hostile, adversely, notoriously.
No.
We are possessing it. So position was.
You have read the Supreme Court judgment. You have yourself read it.
My case, I am possessing 696. There may be auction purchase, there may be sale deed, there may be will, but I am possessing. I am possessing. I am not honored in auction purchase. I am not honored. I did not hand over the position. So when my lord he purchased there, he should have
That what we understand. That is why the suit asking claiming in counterclaim, eviction of use and
When we did not give the position, the time of auction process and during the time of purchase by the husband of the, we never give their position to them.
even I did not give possession to my father, that room. I held it. I never allowed my parents to go inside that room. I was totally preoccupied. When I go out, I lock that room and go out. It was we have gone to that house, 2-room house.
So they must prove that 2 years simulation. Because position.
You show me one evidence of that hostile position.
We are denied that there may be auction process.
No, you show us anything about hostile position. I've shown you this.
Our position is there, Miller. So if we are in possession, we are possessing, so they must file the issue counterclaim within 12 years. Because based on title deed. If there is a title on the basis of the purchase, auction procedure, they file case within 12 years. If there is no possession. They did not put possession. Mere paper transaction on auction purchase is there. So they are sitting over there. Right? We are possessing and enjoying it.
No, I'm giving you an example which is more than 50 years. I've been holding to that room for more than 50 years, but my possession was never hostile. My father never knew, or my parents, my mother and father did not know that I was claiming.
In that case, in my case, it is applicable. In their claim, their claim, right title interest.
Show me one evidence. I'm referring to this issue number 3. You show me one evidence that it is there. We have read the title suit and the judgment of the appellate court. Anything, anywhere, any evidence, PW1 cross-examination or DW1 evidence in chief or cross-examination. Your adverse position.
No, my adverse position is done. Now their title, in their title, they should use all evidence regarding their title on the basis of on the basis of title. So title, the 12 years position, they have sought recovery position. So when they have this position. They are not stated, they are not because of some particular date, when we have disposed them. Nothing is there regarding their title. So they should have filed within 12 years. That is not their. Their case also, but under section 65, if not 64, I'm lost. I lost in the 64 because there is no hostile. It is prior to that. But what about their case? Why there is a case? Now, after filing of our case, if they are not position, why they have not claimed that position? Recovery position. Because they are a land. This is not ancestral land. As per their person.
Where is your written statement to the counterclaim? Page 56. Yeah, this is your written statement against the counterclaim. You're dependent on too. You're plaintiff. Okay. Oh, this is in suit. Where is that counterclaim?
Probably it is not that is the It will record may be there.
Okay. This is your written statement. দাসী এটা দিতে হবে দাসী
Regarding the within statement against contract limited.
both of you are neighbors in the bar table. You should have discussed it and come here and you would have given a Gabura adjudication immediately.
Right, Miller, it is stated that since date of partition, it is 1970.
No, you see, but this is not the point which what I'm saying. You see, we can only say with the written statement that you fought well. Now you see, because this plea of being a sharer was never taken. The defense is also what you call based on adverse position. See, if it goes in title suit, this also goes here. That's why I said we can only say with that written statement that Mr. Deka fought well.
The same plea is taken, para 7, that plaintiff during the lifetime her father possessing his land to his father, and after his death, she herself occupying and possessing his land openly adversely in the initially against non-recoverable property and after the present defendant. The defendant number also not supported by comparing concealing the material facts and without having any position ordered and mutated in the record of rights in respect to Sultan India 1992 in collision with the revenue staff. So in the revenue also, madam, revenue cannot give a titlement. So revenue record. So before issuing the suit, if the mutation is necessary to be recorded, then definitely mother's name will come.
No, you see, unfortunately, the mind is so jumbled up that with your submission, I am reminded of illustration E of section 114. It says all official and judicial acts are regularly done. So that that Namjari was never challenged. And therefore, now to say in the second appeal that the mutation records was in the with the collusion of the revenue staff, it's not there.
Solution is not there, madam. Although there is, but if mutation of the particular person, madam, what will happen when there is no case? Then heirs and successor name will be recorded, madam.
Hmm?
Heirs and successors name will be recorded.
But it's not no plea.
Not
Is it
necessary.
recorded?
Not necessary. Not necessary, madam. There is no necessary government plea, madam, because the record.
Second appeal can be decided without a plea being urged in the.
Is a law point, madam, because the entry substantially affect the right of the parties. The entry made in the revenue record. So, mere revenue record, madam, the revenue record entry on the basis of the heirs and successor, not on the basis of the particular.
Amiya Datta. Judgment of Amiya Datta. Honorable Justice Jain Sharma. Revenue records must be considered.
Consider. So, my lord, first.
Amiya Bala Datta or Amiya Datta.
Maybe.
Huh.
Revenue must be considered for supporting. Their name should be there, but along with their name, my lord, mother's name should be there, my lord, at their given time. No, not whole property. There non-mutation, my lord. Suppose two brothers are there. One recorded in name of the one brothers, my lord. It does not mean that he actually is his right title.
No, you are merely presuming. We don't know that mother may have left the share.
Not left, my lord. There is no pleading that on that effect, my lord.
No, you are taking that plea. You see.
Mother died, my lord, in 1996, my lord. He died in 80, my lord. He died, his son died in 80, my lord. After his death, legal heirs and successor.
This suit is of 95. Mother died thereafter.
Even if she died, even if, no, 92 will be 93 mutation or there. Mutation, at the time of mutation, mother is there.
So mother knows.
This is a recording, the record, date is there, my lord, record is there. So.
No, you did not. You see, the revenue records were never brought. Today we can't say what is there. Just why I'm saying illustration E of section 114 of the Evidence Act says all judicial and official acts are duly performed. So therefore, we don't have to go into those aspects.
There are several judgments that mutation entry cannot give title.
That's why.
Cannot title.
No, that's why I am not on those judgments. I am remembering only that Omya Bala. That.
It is 2005. It is 2005.
Amiya Bala Datta versus Mukul Adhikari. You have got it. She's armed. Because Mr. Datta, Mr. Dekha, there is second aspect of it. Number one, if that mutation entry is wrong, assuming that the mutation entry was wrong, Section 154 bars civil code it may not touch on that, but it may say that yes, title is of X, but that the entry in the mutation record is wrong. That civil code can't decide.
Their action successor, their name will be there. Their name will be there. Name will be recorded in, suppose if mother is there, it does not mean that Dhaka will not get the but and that is changed because he purchased the defendant's father.
No, everything is accepted.
So, my lord.
Everything is accepted. But I've shown you your written statement. You have never claimed. Once you're not claimed, it is waiver. Once it is waiver, there can't be a presumption of title flowing through your mother. If the plea itself is not taken.
Mother, definitely mother get below the action section.
No, we don't know.
Definitely they will have to say below.
No, I don't know.
They claim that mother is there, see extreme is there, right? Therefore, our name was recorded. That is not, is that their claim, counter claim is a suit below. So they are plaintiff below. They are going to suit, they must put all the relevant materials. Mother is there, they actually get mother below in the time of recording their name. So mother is there, even if mutation is not there, suppose mother's name is not there, then their title is not extinguished. That is my claim. Mother title is there, very much there.
Then what happens to order 625?
That's
625. This should denial should be specific.
it's not them because they are suit. Because their mother is there, pleading is there, their mother is there.
No, let me you see. Let us not go on that because all these are hypothetical. The question is somebody has come rightly or wrongly asserting title. There will be someone to say that no, your title is not there because of your intervening what you call title of the mother.
So materials available on the record. At the time of death of this son, there is a mother, there is a wife, there is a
So there may be not let us forget three. Let there be 300 what you call legal heads.
declaration of right against interest, entire property by it's not tenable, my lord, entire land. They will get their share, my lord.
Where is
I
that
have no
defense?
objection.
Where is that defense?
Because there is breeding is there, metals available on the earth. And
Can be accepted. Second appeal, it can be accepted when there is a concurrent finding of fact.
finding of fact, my lord.
Have you taken this in your evidence? Your evidence has PW1. Unfortunately, it is not there. Then you look at the cross-examination of DW1. You have the records. You just see in the cross-examination of the intervening title of the mother. I think that cross-examination is not there.
Indo,
I have not read it thoroughly, so I may have missed it, I don't know. But in what you call superficial reading, I have not found that please there in the PW1 or cross of DW1.
So, community more data আছে মই মোৰ মনোযোগ কেনে হ'ব সন্তান 15 বছৰ যেনে যে আৰু 19 বছৰ পৰিবার 1985 চনৰ দাদা 19 আমাৰ লগত একেলগে আছিল 1988 চনৰ দাদা আমাৰ পৰা বেলেগ হৈছিল বেলেগ হৈ 19 পত্নী আৰু ছোৱালীৰ সৈতে একেলগে আছিল মোৰ দাদা আৰু 19 বিয়া উন্নতি হোৱা নাছিল বাবে মই বিয়া দেখা নাপালো 19 লগত আৰু 1999 চনত কামাখ্যাত বিয়া হৈছে মই ক'ব নোৱাৰিম আমি ব্ৰাহ্মণ মানুহ চক্ৰৱৰ্তী বেলেগ কাষ্টৰ মানুহ বাবে আমি বেলেগ থাকিবলগীয়া হৈছিল সেইটো ডিসপিউট মেলত
That may be there.
মই নাজানো দাদা মোৰ লগত থাকোতে তেওঁলোকৰ বিয়া সম্পৰ্কে মই কেতিয়াও দাদাক সোধ কৰা নাছিলো মই অবিবাহিত মোৰ দেউতা আন এগৰাকী ছোৱালী
Because Mr. Deka, had I believed in this caste system in my previous life there, I would not have been a good friend of Mr. Satar there. Nor I would have been a good friend of yours or Mr. Mahanto there. Had I believed in caste system.
ছোৱালী আৰু দাদা তিনিটাই
No, it is don't there. It's not there. In chief and all, you can go through it very leisurely. It is not there. Cross-examination, I found some difficulty in reading some part, but there in cross also of DW1, these please that mother is not there. And in a lighter note, I'll tell you something. Absolutely right, nothing to do with this. I was once hearing a great what you call cardiologist. He was giving a speech in TV. And he said, when the anchor asked him, he said, now every problem of heart is happening because people have lost faith on God. I said, why? What is very absurd coming from a doctor? And the doctor said, no, earlier times, anything happened, people used to fold hands and say, it's God's will. And therefore, it was a shock absorber, nothing happened to the heart. Everything was on God. Now everyone says that I am so and so, I am so and so, and everything hits the heart and he dies. Correct. So here also he says everything about himself. Does not bring mother in between. Had mother been there, she would have been a shock absorber through which you could have claimed title. But you forgot mother at that point of time.
not available to me.
You take it up at 2 o'clock. Go through it. But it's not there. A cross-section DW1, could not have read it fully. Superficial reading, but I did not see your mother there.
Date of death from the mechanism. Somewhere there is the date of father.
No, whatever we built up at 2 o'clock, whatever you want to do. We'll not take it up at 2 o'clock, we'll take it up at 3:30. Because no, we'll complete it because the difficulty.
There is that to probate method connected. Because
Okay.
there is already sometimes is necessary. Because non-probate case, then was given to a house.
No, because you see, I could have continued, but I have a mortal fear that the lawyers will beat me up.
Some other may be part of it, but otherwise not, it is difficult again,
No, you should be happy if it reaches before any other bench.
no,
You should be happy.
no,
In English, we call it good riddance. No, will,
I take the permission is giving, I can certificate to give the address, it is not our, permission is giving, by which code I can take a certificate.
I said as well that some parts.
permission is not required, I think.
They are also not giving.
Okay, just say, Mr. P.S. Dekar, Senior Counsel, Ms. P. Bhattacharya, Counsel for the appellant, as well as Mrs. S. Sharma, and Counsel for the respondent. Both sides have jointly prayed to permit them to obtain certified copies of the evidence. So prayer is allowed. The on application being made, the registry shall provide certified copies of the evidence from the LCR. Next matter stands adjourned today. List again on 29/1/2024. First, we are reserving it. You can have it on 2nd, then 2nd of February. 24. এটা ফাইল তাতে আছে। এটা ফাইল তাতে আছে। এটা দেখুন।
কি তারা ছবি
ফাইল এটা অরিজিনাল ফাইল।
or motion item 6.
Other two single cases also directed them to decline or when the one prayer was allowed to be supplied. There were three same cases, same order.
Okay, yes. In fact, I reply. You've seen this order?
Yes, you are there.
Okay. We pass the same order. नाम change हो। Mr. Gaur, in this, just make these corrections of these case numbers and all, give it to the courtmaster, will incorporate. Say, you're Mr. M. De, J. Bharali, for the respondent, Assam coming with, respondent number 1. All the respondents? Okay, all the respondents. J. Bharali. Yeah, मिलेंगे वहां से. JC Gaur will be same. Just make that corrections and give it. That case number and then the suit number and name the parties. Item 7. Yes.
May, Your Worship. My lord, I have challenged the penalty to order 3/11/2023 by law, whereby my application filed under order 7/11 was dismissed by the Alliance Trial Court, my lord. The order is at 3:30.
Where is your petition? Order 711.
My petition, Your Worship, will find at page 55. Page 55. May I read it?
No, no. But Mr. Bhatti, we don't find anything wrong in this order.
My lord, only one question is, it does not disclose the positive breakdown. Why it does not disclose the positive breakdown? Your lordship will see, so far the agreement is concerned, that has been entered into between the plaintiffs and the defendant. But the permission was obtained in the name of different persons, that your lordship will find at page.
Can that matter be decided by this court without any evidence?
My lord, because the annexure F, I annexed.
No, I understand, but you see, this is the issue of fact.
Because when the plaintiff has no right to institute the suit matter in this particular case, why he is not there? Because the earlier agreement was said has already been substituted by a new agreement.
These are all matters of fact. How can, on the basis of an evidence, without an evidence, this can be decided?
Supreme Court has decided this matter, my lord. May I refer the judgment of the Honorable Supreme Court, my lord. Your lordship. May I give one copy of it, my lord? My lord, first of all, inside paragraph 23(8), my lord. Paragraph 25, inside paragraph of 23. Paragraph 23(8), my lord. May I read it, my lord?
Just. $25
23.8.
at page,
Inside page, at page, my lord, here, page number is not given.
23.8,
8,
yes.
having regard to the order 714, the documents filed with the claims are required to be taken into consideration when deciding the application of order 7. Rule 11A, when a document referred to in the claim forms the basis of the bench, it should be treated as a part of the bench. Accordingly, my lord, so far this permission is concerned, that has to be taken as the part of the bench. Now, my lord, you will also will see, G. In this construction, sir, this court was elucidating on the underlining of this order 7 to 11 CPC and continuing basis precedent of this court held as well. It could thus be seen that this court has held that the power conferred on the court to terminate a civil action is a drastic one, and the conditions enumerated in the order 7 to 11 are required to be strictly adhered to. However, under order 7 to 11, the duty is cast upon the court to determine whether the claim disposed in court of action by scrutinizing the elements in the claim, read in conjunction with the documents relied upon, or whether the suit is barred by any law. This court has held that the underlying object of the order is that when a claim has been disclosed in court of action, the court would not permit the plaintiff to unnecessarily protract the proceedings. It has been held that in such a case, it will be necessary to put an end to the sham litigation so that further judicial time is not wasted. Now, my lord, there are 27.
27.
Yes. It was further held that if on a meaningful reading of the plea, it is found that the suit is manifestly vexatious and without any merit, and does not dispose the right to sue, the court would be justified in exercising power under certain circumstances. My lord, so that my lord, it does not dispose even the right to sue in view of the substitution by a new contract, my lord. Under section 62, my lord, it requires the consideration by this honorable court whether it can be approved. Now, my lord, for that one, my lord, may I take your lordship for 1 minute? The plain para 5 at page 24. Page 24, my para 5. Have you got it, my lord? Page 24.
Yes, I'm there.
Middle of it, man. But in spite of these diligences, efforts as well as due to the delayed process of demanding himself, the plaintiff was not able to obtain the from the DC, Kamru, Guwahati on Satosa, which was well within the knowledge and information of dependent all levels. Now, my lord, I am skipping over for this one, my lord. In the meantime, for making the payment of balance agreed consider the amount to the dependent, the plaintiff said also arrange finance from but due to non-existence of registered charges in fact of obtaining dated 1/4/2009. Now he says that he obtained the permission, self permission. The self permission is in the different names, though they are the wives of the plaintiffs number 1 and 2. Now, my lord, I have annexed that one as annexure, so that there is the substitution of the agreement within the meaning of section 62 of the contract act. So where is the question that you obtained the permission, my lord? And that there is no substitution of the agreement, man. If the peace agreement has entered in between these two words, in that case, the
After paragraph 5, which paragraph you were reading?
paragraph 5, my lord,
Yes.
last line, at page 24, my lord, 25. 25, my lord. In spite of that, all along, register said, in spite of obtaining BPP self permission, dated 1/4/2019. So, but this says this permission is concerned, my lord, that is in the name of the other swear, that is the rights of the plaintiff. That was okay. So there was a substitution of the earlier agreement in view of the permission which was obtained, and that has, I have annexed at page 67 of my thing. That was the permission. Note in the names of the pages. So where is the right, my lord, to choose? That you obtain the permission and I am bound to execute the schedule. As my lord, your lord will see name of the purchaser. Namrata Sharma Sansan.
Where is the order impugned?
Impugned order, your lord will find at page 30.
30,
1 3.
1, 3.
And this aspect has not been dealt with the
You have a copy of that agreement with you?
Yes, I. I'm sorry, my lord, I could not.
Spending 10 rupees is a costly affair. No, what was your submission? Please come again.
My lord, it does not disclose the position. Why it does not disclose the position? Because the plaintiffs have no right to sue. In view of the substitution of the agreement with the meaning of section 16. And that especially I have taken in my application, I
In this agreement, the plaintiffs are the second party.
No, plaintiffs are the plaintiffs. Plaintiffs are the second party. Yes,
Plaintiffs are second parties.
yes.
So why a party to an agreement cannot sue?
Because this agreement has been substituted by a new agreement within the meaning of section 62.
Where is that?
In view of the permission which was obtained by the plaintiff in different way. That your.
In the name of their wives.
Yes,
That then is not it's permissible. Under the Assam Land and Revenue Regulation and the rules, settlement rules frame they are under, if a husband purchases a land, he has a right to have the wife's name mutated.
that is a different aspect. That leads to the mutation. Here is the question of agreement itself. So that it can.
No. You may refuse to do under that. You ask him to have the self permission made under the new name, the old name, but it can't be.
Because they did not.
No.
They did not. That is the question.
No, if it is a transfer within the family members, it's not a novation of contract.
It is the novation of the contract, my lord, in my humble submission. Your lordship may take it on Monday, and I would satisfy your lordship with the.
No.
judgments of Different high court and.
No.
whatever Supreme Court, it is the novation of the contract. Because once there is the novation of the contract, my lord.
You see, settlement rules permit the mutation in the name of the wife. You see, a father can have a property purchased in the name of the minor son.
different thing, man.
No, if the minor son can't be in, you see,
My-
if they
minor son-
can't enter into an agreement, father can do it.
He cannot, but his father can enter. That is a different express, that is regarding the settlement of mutation.
No,
And
Mr.
it is- yes, it's a
This,
question of
no,
time and
no,
money.
having taken money as a builder, and
No,
then you don't want to give the flat, it's something else.
That is a different thing, my lord, whether I have.
No, we'll be dismissing it.
My lord, my submission may kindly be reported to the against.
Yes, yes.
Yes, because it is the innovation of the contract. by
We'll record it.
virtue.
We'll record it. I'll pass it in the chambers because I have to go through it. Item 8. Oh, I'll take a break and come back. Just a moment.
May I place your lordship? My lord. And I sir. Just going to my lord. You know that. The successor certificate was issued to the wife. Applicant. You will be a last.
This is the appeal. This is an appeal.
Applicant. The successor certificate has been immediately cancelled by the district judge. By taking order that. Holding that in the petitioner who challenged the successor certificate.
We should notice.
Also, but I am a nominee, I filed a certificate paying for service benefits and other benefits. So nominee is entitled to the benefits. This-
Okay, I'll issue notice. Mr. B. Hussain, counsel for the appellant. By this appeal under section 384 within bracket 1 of the Succession Act 1925. The appellant has assailed the order dated 23/8/2023 passed by the London District Judge Nalbari, by which succession certificate granted in favor of the appellant was revoked. Appeal is admitted for hearing, call for the records. Notice steps within 2 days. List on so and so. We should notice. Take steps within 2 days. Item 9. Yes.
In this case, your lordship, the petitioners at the division 1 and 2, due to non-supply of documents also by the plaintiff side, the plaintiff is respondent number 1 and 2, they are unable to file their WS in this title suit number 24 or 23. And they are unable to do it, and because they was expert into not a file, they close them and WS and fix for area. And after that, they filed a vacating petition. The ground that due to non-supply documents, the council was unable to file the written statement. Does not consider after that I do not order dated 1/12/23 that this one was rejected. This 37 is the order.
Where is the plaint?
Page 50.
16.
15, it is from 16. Among the family members, there is a right interest and partition of the.
But there's no document annexed to the plaint.
Yes, I have. been certified in the-
Hmm? There's no document annexed. If on that ground you would not get a adjournment.
Given your person to file a WS, otherwise the right will. Their position land, and they're included in among the community ancestral property of the plaintiffs and dependents.
You see, you could have filed your written statement and paid for to allow you to participate, but you did not file it. Even after the suit has proceeded ex parte against you for not filing a written statement, still you don't file your written statement. You merely make a prayer that you please vacate the order, so I'll file my written statement. That conduct will not be acceptable. Because you see, I am a part of that, what you call that hammering process to the trial courts to dispose of suits early. I take responsibility of that.
Once or twice, because the petition also subsequently I have certified.
No, that's okay. You see, but
Then I approve this.
but you see, here in the administrative side, we are directing them to proceed with the suit. The Supreme Court has passed several orders saying that time-bound disposal. We had, by orders of the Supreme Court, we have also amended our High Court Civil Court rules and orders, inserted paragraphs for case management. No, because you see, you'll have to show a jurisdiction error. Had you filed your written statement, then I would have understood that, okay, you're bona fide. But written statement was not filed. Even after expiry, you're not filing it. You are asking the court to vacate it.
They filed a petition, vacating the order.
But that is right. It can't give an adjournment when it is closed.
Even if this order.
We'll adjourn it. We'll take it up next Friday. By that time, if you file a written statement before the trial court and produce proof before us, then we'll consider. I'm just adjourning it. The learned counsel for the Mr. S. Islam, learned counsel for the petitioner, pays for an adjournment to enable him to obtain instructions as to whether written statement has subsequently been filed in the suit. Accordingly, matter stands adjourned today, list on 12/1/2024. Item 10.
Yes, please, Your Lordship.
Yes,
Lordship, transfer petition, this is
transfer. What is the ground?
ground lordship page 6, kindly see lordship. The
You did not tell me.
The petitioner has a 2-year minor daughter, your lordship, and she has been residing here at Guwahati,
You are working woman? No.
working.
You are working woman. Then
That she, June 23, she was appointed. And it is difficult. on
no,
her
you see,
part to lordship.
it's only up to ho jayegi.
lordship 170 kilometers from here. That is difficulty, lordship. Infant child lordship. Otherwise, the petitioner is ready to contest the suit. Final daughter lordship and he has been.
Heard Mr. A.R. Shom, counsel for the petitioner. Transfer of matrimonial proceeding, petitioner is the estranged wife of the respondent, transfer of divorce proceeding being so and so. From so and so to so and so. Notice steps within 2 days. Postal district track report. Next. As notice has been issued in this application, the further proceedings of TS within bracket D, number so and so, pending before the court of London District Judge Hojai, Shankardev Nagar, shall remain state subject to production of certified copy of the order before the London Trial Court to bring the order to its notice. Just on so and so. Date after 6 weeks. Take steps within 2 days.
Oblige your lordship.
11.
There was an order passed by this court.
Okay. You want it after some time or you want an adjournment? At 2. Possible? Okay. The notice is out?
Notice, sir.
Okay.
Though they have not, their name is not shown in the poisonous matter, but they have to appear.
Item 12.
They filed a title suit matter, and in this title suit matter, they filed a petition under section, under order to a fees matter for judgment on admission. The state petition was disposed of. Against that order, I filed this present one, here. What happened, my lord, in the meantime, London filed an IA regarding maintainability of the fear. So I need some time to file objection, my lord.
Just a moment. Which is the order impugned in this, which page? Is that impugned order?
Here's one of mine.
119. Just a moment. Mr. Hussain, you will be delaying your own case. Mr. The respondent is rightly stating. Mr. Gogoi is rightly pointing it out. If a judgment has been passed on admission, appeal will lie. Because if it is being delayed at your
Judgment was not passed, my lord, only that petition was disposed of, my title suit is pending, and it is yet to be declared judgment. That, my lord, we have filed an IA under order 12 rule 6, my lord. So thereafter, my lord, the court disposed of trial court disposed of that petition only, and the title suit is fixed for judgment on admission, not declared judgment. So my
but that is, you see, if it is, if the suit is decreed on, already a judgment has passed. It is merely a clerical work of writing the order.
No, my lord, judgment was not passed.
My lordship, page 120. Yes, accordingly, the petition of prayer for judgment on admission is allowed in after order. Please detail page 120.
No, but where is the judgment? If there is no judgment, there is no appeal.
No judgment, my lord.
Any order passed under order 12 rule 6.
No. You see, it can't be. Let us say today, I say, in the last matter of Mr. Bhatti, I said that I'll pass orders in the chambers. No, I'm just telling you, this is also an order. I'm online. You can have a transcript of my statement made and produce before the court as evidence that, look, the court has said that judgment I'll deliver in the chambers. Like there is no judgment at all. Then what is the remedy?
Each for submission, I got the judgment, it is uploaded. Then on letter on. Yesterday I am.
Dashi? Page 119. You got it?
Sundaybhai.
No, I don't think, yeah.
I downloaded the equal subject.
Yes, Mr. Hussain, you take note of this.
My lord, my lord, when, because first I am not aware
Show
of
copy
that
to
matter.
him.
But
Show a copy to him.
my
You have a
lord,
copy, no?
the Indian order is there, my
You don't have a
lord,
copy. Acha.
page 117.
No, that's okay. You see, judgment has been pronounced and then it took some time to declare it. Because Mr. Hussain, before commenting, I personally think that when I'm pointing out a finger, 3 fingers are looking at me. So you see, in the open court, I pronounce a judgment, I dictate. By the time it is transcribed, at times it so happens that it takes 4 or 5 days also. Merely dictation being transcribed, it takes some time. Although I'm aware, I have a list with me of which judgments could not be transcribed. But it happens to me daily, day in and day out. By the time the orders are online, at times, even in bail matters, it takes 2 or 3 days to have the matters uploaded. In a criminal appeal, I acquitted a person. And then when at the time of uploading it, my secretary found a blunder in that order, and we had to rectify that blunder. So even an order of acquittal took 5 days time to upload.
Maybe my lord, what time will be allowed to clear your position?
Right.
As I have.
Give a copy to him, make a photocopy and give it to him. Mr. Hussain may not be knowing it. At the outset, Mr. S.R. Govey, counsel for the respondent, has produced a copy of printout from the trial court website, order dated 4/1/2023 of the judgment being pronounced by the judgment on admission being pronounced by the trial court. Full stop. Let a copy of the same be provided to Mr. M. Hussain, counsel for the petitioner, to enable him to obtain instructions. List after a week. So what is the interim order? Okay. As judgment has already been pronounced, the court does not find any reason to continue the order of stay of the proceedings of TS 26 of 2017, which was passed on 15/3/2023. So list after a week. That interim order we are not extending because
That's wrong with. Yet maybe it's better than I have not tried it only that.
Mhm.
Yet maybe it's that matter.
Okay, 22 January 2024.
Already.
What is this IA for? Oh, acha. Just also said, Mr. S.R. Gogoi, counsel for the applicant, and Mr. M. Hussain, counsel for the for the opposite party. You should notice on this application, returnable on 22/1/2024. List 24 for objection, if any. Okay. 13.
Your lordship,
Yes.
this the key is
You can deposit 50%.
can deposit. Only thing, lordship, we had filed one IA, was allowed, and lordship will credit the first item has been submitted by the registry. So the notice will be to 1 ABCD and 2. That is the,
There's no stay application here.
no stay application we inadvertently, but with the appeal itself, lordship may direct us.
No, no, it has to be there separate. You file it in the meanwhile.
Okay.
MSc appeal. Mrs. R.D. Mazumdar. Next para. Say that notice steps within 2 days. Next para, on the prayer made by learned counsel for the appellant, she is permitted to file a separate application for interim relief, if so advised. Notice is made returnable on when? 21/2, list on 21/2/20.
And your plans.
This cost title has been corrected.
Yes, lordship will find office correction 13/10/20.
No, it's okay. 14. Somebody made a prayer for adjournment. Yes.
So last occasion, I was asked to take instructions.
No, yeah, not, I was on granting adjournment. Only the thing is that other side should be informed. Correct. He wants an adjournment. Okay.
Right now, your lordship, how much grant your lordship I got on what are your lordship? Regarding the area maintenance of 125 proceeding your lordship. That information is in here. But so far, in 25 your lordship, how much area is there your lordship, I don't know.
No, because you see, this is where we have directed to tell us the amount. What is the calculation? No, we give the, you exchange that.
Yes.
total amount was 97,000 and honorable Sujit Minister directed that 2,500 per month will be deducted from the salary. And accordingly, it was deducted as per this order since May 20.
No, you see, last time also we did not pass any order only on that ground. You just give me a calculation and show it to me, because if I am to do that calculation, I'll do it at my sweet will. To do that multiplication and addition and multiplication and to find out what is the amount due, what is not. Last time also we adjourned only on that ground. We told you to apprise this court about the area maintenance. Only thing you have to do is to do your homework, make that calculation and give it to me a chart. If you want me to do it, we'll fix it after next view, what you call 2025 view vacation. Because I have to requisition a calculator, I have to take it home, make that calculation. I can't spend public time doing that calculation. 2,000 rupees into 9 months. Those calculations if I have to make, I'll do it in the next vacation.
1 month of the salary. Okay, against that order, they are not before the court. They are against a different order. The
Yes.
interim order is different. Interim order, just to find the page 27.
You see, it was your submission that they are only paying 7,000 rupees maintenance as under 125. That is what we have recorded on the last date. Correct. Now, in this, they have challenged the order passed in this miss case. Correct.
Yes.
That is under section 24 for pendant light. And this, no, it's not separate. Because there is a condition in one of the subsection that the maintenance granted elsewhere has to be brought to the notice of the court. Where is that? This order. Page 27 order. Yes.
The middle portion, he has further alleged that he had filed miss case number 45 in 2015. That's a lawsuit.
Yes.
Under section 155 CRPC against the respondent, which was tried by the learned court of learned citizen Noailgaon. After conclusion of the trial, the learned citizen Noailgaon had ordered the respondent to pay 4,000 per month to the petitioner and 3,500 per month to the minor son as maintenance. Against the order, respondent had preferred criminal incident number so which was dismissed by the learned citizen judge Noailgaon by judgment and order dated 11/9/17. The respondent being accepted preferred criminal petition number 1/006/17 before the Honorable Guwahati High Court, which was also dismissed by judgment and order dated 12/2020. Then even after passing of the application for the opposite party has failed to pay hard any money to the railway, any money to the railway employee and going 50,000 as salary. So there is complete disclosure, and disclosure what you can also see from the plaint for divorce filed by the husband. Husband himself has disclosed before the district judge that his plaint is a paid well.
Yes.
Page 6. There are 6. Page 13. Then the respondent filed this case under section 125 CRPC for her monthly maintenance along with the minor before the citizen Noailgaon on 7/10/15. The petitioner appeared before the honorable court and submitted again objection against the petition of the respondent. After completion of the trial, the honorable court was pleased to pass an order directing the petitioner to pass monthly maintenance allowance for the respondent along with the minors amounting of rupees 7,500 only per month, which was for passing the judgment and ordered on 23rd December 2016. They have been dissatisfied with the increased judgment order by the learned citizen Noailgaon, the petitioner committee petition under section 22 CRPC on 11/9/17 before the accused petitioner in the state case honorable Session Judge Noailgaon passed the order by justifying the order passed by citizen Noailgaon and thus over. Then subsequently, the petitioner approached the honorable Guwahati High Court, and thereby he submitted a criminal case by order by number 10617, and the same case is pending with the Alfaz Ali. In the same case, the Honorable Justice passed an order on 17/18 by mentioning that the petitioner shall continue to pay maintenance 6,000 per month as an interim measure. This was ultimately dismissed as evident from the order itself.
See, if I recollected correctly, this revision, the ground taken is that there is a Supreme Court judgment saying that there should be a disclosure of assets. That is number one. After that, there is again another follow-up judgment of the Supreme Court of India where it says that it is mandatory. Correct. So the disclosure required is when you are claiming maintenance, you have to disclose your what you call your financial disclosures also. 28.
Only on the part of our.
Just a moment. Yes.
Second paraphrase with me.
Yes.
I find that the respondent has participated in this case.
28. I find, yes. Okay. Okay.
That is that opportunity. On that day, your lordship, I made where your lordship. The petitioner, your lordship, actually, he did not got the copy of this petition, your lordship. And accordingly, he failed to file his objection, your lordship. But consequently, he could not file his affidavit, your lordship. Regarding asset and liabilities, your lordship.
And as far as the last quarter, there was a direction that is why difficult to maintainability also. So if there is an ex parte order, we do not find that very if it is an ex parte order, he has still
No, just a moment. That Mr. Khan make submission first. Yes.
First of all, your lordship, my submission is that, your lordship, in the last occasion, I was asked to apprise the court regarding the area, how much area is there. Regarding that, your lordship, I have no instruction, your lordship.
Okay.
I communicate with my client, but he said that it will take some time to furnish this information.
Okay.
And regarding this issue, your lordship, in morning, one of my friend, your lordship, made prayer for adjournment of this matter. And
No, we'll not adjourn it on that ground.
and the whole issue is regarding the quantum, your lordship. In here, in this proceeding, your lordship, 15,000 has been granted. But earlier, your lordship, in 7,500, your lordship. Altogether, 22,500, your lordship. So, regarding only this, your lordship. Our issue is regarding the quantum, your lordship.
Where is your salary slip? Have you annexed it? Page 21.
Service slip, pay slip, your lordship.
Yes.
Page 21, your lordship. In here, your lordship, my gross salary is 54,888, your lordship. And deduction is
So where do I find that?
this
22. Okay. Yes.
In page 22, your lordship will find a code attachment 25,000, and thereafter gross is 54,888. And after deduction, your lordship, right now, your lordship, the petitioner, he has been receiving 13,388 net pay.
So this is only an attachment of your money,
Yes.
but it's not being transmitted to the wife. It's only an attachment. It's only a court attachment. That means your money is there in the bank and it is attached.
Can we say my friend, your lordship, whether he is receiving this or
No, if because that you will know.
But as per my instruction, your lordship, the court attachment means they are receiving the amount.
No, everything is not so easy. There has to be an order of the court because the bank will not release without there being an order.
Regarding 10,000, your lordship, there is order. What attachment, your lordship?
There is an order.
10,000, but regarding 15,000, your lordship, I have not found any order.
Where is that order of 10,000?
10,000,
This one.
that order.
So only 10,000 will go away.
How much is receiving your lordship and can say your lordship?
He's making a statement 10,000. That means 7,500 as regular and then 2,500 as area. 10,000. 15,000 amount is in your bank.
Yesterday,
Hmm?
order was passed.
Is the state by order of the Supreme
Where is that?
Because this order passed on 25/2/2022 and the stay was granted
22 to 23. Moderated 22 to 2023.
Where is this order of 25 to 22?
Yes, 25.
The impugn order. But this 7,500 has to be adjusted against this 15,000. You can't get 15,000 plus 7,500. Page 28, yes. Yes.
There is no dispute to the fact that the opposing party is the central government employee railway.
So by the time you are reading it, I have read it. That's why I'm asking you. You see, 15,000 is the civil order in section 24 application. Criminal 125 is already there, 7,500. Do you think you are entitled to both compensation, what you call both maintenance?
Yes, it can be granted addition. There are 60 and 60.
In Rajneesh, what was the income of the husband? It was 2 lakh rupees to the wife. Correct. What is the husband's income? 54 lakh. No, 54,000, that's what I'm saying. You see, multiplication and division is something which can do, I can do that. 7,500 plus 15,000 is how much? 22,500. Out of 54,000 salary, can you get that much? Can you show me any judgment of any court where it says that out of 54,000, you are getting 22,500? Almost 50%. Can you show me a judgment? We give you time till 2 o'clock. Otherwise, it has to be modified. 7,500 must go. It will merge with this order, and you will be getting in the civil side 7,500 and 7,500 in the 125 proceedings. Unless by 2 o'clock you show me a judgment that it is permissible to have out of 54,000 salary a quantification of this amount. Plus in 54,000, where is that page 22? Where is the income tax deductions media? Four thousand 800 into 12 would be 1 lakh more, 540, some 650. No. You see, 50, let us say 55,000 for sake of convenience. So that means 10 is 550 and 110. So 660 is the annual income, correct? Is it within taxable limit or it's payable? Income of is a taxable income. So income tax is not deducted here. No, not, you see, you justify it, you show us from any judgment you can, where 50% of this can be done, and this is only an interim. We are not making it a final assessment, because in the even after 24 application, the quantification may always vary. 24 is not forever. 24 so order under 24 is not static. It's not forever. It's subject to alterations by the court. Correct. After 3 years, there is some enhancement again. After the Supreme Court judgment, there is a ratio given now. At 2 o'clock, you come. If you can show me any judgment, then we will not modify. Otherwise, we'll modify it. Your 22,500 seems to be excessive. When income before deductions is 54, gross pay is 54,888. You show me, satisfy the court. We listed again. Because we are already, what you call, because he'll show you the order. In fact, in my table, apart from one matter which I could not sign, I had a small meeting, I had to go out. All others I have signed. Your order is already signed. Except for one file which I could not sign. Except for one file that is there, you will not find any other. Each and every order has been signed by now. It'll come, it'll come. You just tell the registry it'll come on Monday. Just tell them they'll get it listed.
Bail list item 16, bail hearing.
Officer Nath, make a mention on Monday. Make a mention on Monday. Correct, if required. We'll get it listed. Yes,
Yes, your lordship, here the petitioner was arrested under the NPS Act.
okay.
And he has, prior to this bail application, his bail application was rejected twice by this court. And now, your lordship, there is a total for 51 days. Now he have been prolongedly incarcerated. However, the trial has recently been commenced where there are 20 witnesses, but not a single witness has been examined. Even the investigation agencies are also relying upon 37 documents. Moreover, there are total 6 accused, out of which 5 are out on bail, and the petitioner is before your lordship.
Yes, what do you say?
Time of 2022. And you state fixed for the exit prosecution. And they had 1/2024. That is already been started, and the date is 11/1/2024, fixed for evidence.
How many days today?
Till today, your lordship, 451 days.
We have 2 officials. The commercial quantity.
No, but if the state delays the, what do you call, the trial, this charge sheet was submitted when? This is 423. 423. But in this space, there will be a lot of time taken in the trial. It has to be released on bail. What is the previous order of cancellation of the rejection of bail order?
There is page number 45 of the petition.
45.
Please come again. What is the date when the charges were framed?
Charges are framed, Lordship, were framed on 27th and 2020.
Let me go through it. I'll fix a date for passing of orders. Let me-
Lordship, in the earlier order, Lordship, in the paragraph number 13 of the earlier order, Lordship here also, Lordship has, opinion regarding the maximum period for which an under 12% can be detained. That was also explained. The para 13 of the earlier.
No, you see that, you see, those are considerations.
Lordship.
But the fact is that on the last occasion when we rejected the bail application, he was 245 days behind the
Yes.
bars.
Yes,
Now it is 451 days.
yes, yes.
So if the charges are framed only in October, 20 witnesses,
Lots,
20 witnesses will take not less than a year.
lots.
Should he be incarcerated for that long? From his position, these drugs were not seized.
Your Lordship, a same kind of instances in other criminal, in other NDPS, where the other coordinate benches has, held, this long incarcerated period based on the recent guidelines of the Supreme Court.
No, you already know
Yes,
why the reason we have rejected earlier.
yes. Then there was a time period was less.
And
But now it's.
and the ground on which it is rejected is also passed by the Supreme Court. They have taken that. And you see this, this is a case. There are two things. Number one, let us be practical. Number one, you just take out your mobile and read the what you call last is, that means 22. Year 22's seizure of drugs. You take out your mobile and just give a search. Drugs seized in Assam in 2022. Just check it out.
Yes.
Just check it out. Drugs seized in the state of Assam. You will find a statement of DGP coming. What is the figure? 2000 plus crore.
The first one shows that heroin worth around 4.8 crore. In
No,
Assam.
not 4.8 crores.
It's a Deccan Herald. Deccan Herald coverage,
No, to 2022,
2020.
2000 something. 2000 something crore.
Yes,
Correct.
1,402 crore were seized and drugs worth rupees 855 crore.
So that is the amount of seizure of drugs. So I don't know in my backyard when the drugs will come in, we don't know. Correct. Per capita, you just divide it by the per capita, what you call population of the state of Assam. Then you will understand the amount of drugs which is coming in. That is number one. There is a practical aspect. There is a second aspect also. The drugs are so easily available in every nook or corner that it is damaging one part of the society. It is making people worthless, one part of the society. This is the second aspect. And again, there is a third aspect. These people have good connections from porous borders, and they just go vanish. You will find that in your case, the trial has been held up because of the fact that the accused who were granted bail did not turn up. So they just vanish. There's a porous border, they just vanish, and they are not to be found. There's a fourth thing. After the judgment of this case, Justice Puttaswamy, we can't direct that what you call the accused be secured with a what you call that what chip it is called, that location chip.
Ah, okay. That's in fact the new judgment.
Yes, location chip we can't do it, but you find in all the what you call everybody calls us third world countries, and in all the first world countries, when bail is granted, you have to have that chip what you call that band attached to you.
Yes, but in that case, your lordship may, in as a conditional, Then mark is present in each and every alternate.
No, if
day
he
of-
vanishes, what is the point? Supposing I do the vanishing act, you all are sitting here and I don't come up till 2 o'clock. If I do the vanishing act, what is the mark of presence indicate? Indicates nothing. These are 4 or 5 reasons where it's very difficult. These people will not mind. You know something more. This is a case diary I have seen earlier. This is something I'm recalling from memory for last how much months? 5 or 6 months. There is an entry in this case diary by the IO that at that point of time, drug of 50 crore was seized, which is highest highest single seizure in the state of Assam during that period. There's a note of the IO in the case diary. The worth of seizure 762 grams, or maybe plus or minus 784 or something, was worth 50 crore rupees at that time, and not that day, that was one of the largest seizure of drugs in the state of Assam. I'm saying it by memory. I'll find it out if you want. Huh.
That is why only just my clear with humble clear with.
No, I get it, but you see,
Based on the next of ten.
it is that
We are
huge
local
quantum.
resident of that area on.
It is that huge quantum. They have, they have validated 50 crore. There's a note of the IO. I'll not be able to find out now again. It's there somewhere. I will not be able to find it out. There's another note of the IO somewhere. It says from this person, he is having a facade of a mineral water bottling plant. And from his house, 20 lakh rupees was seized, which is 594% more than his known source of income.
It's, your lordship, regarding that 20 lakh, what happens is that will come out in the trial during cross. What happened is after this accused was been arrested in this matter. Later on, this IO said that, okay, we will leave your son if you can come and manage with 20 lakhs. After that, what happens, your lordship, the mother, the only mother, she tried her level best, sell one property of that of her and arranges 20
No, but
lakhs.
on the day of, you see, that happened on the day when the IO went to the place and you see, he was tracked. The city the city says that he was tracked and he was found some place, and what he did was he used a fake SIM. A fake SIM was created, a clone number was created, and that was found in his mobile. He has got 2 mobiles which were seized. And out of that, one mobile was having a fake SIM, out of which transactions were made. And this truck owner, truck driver, from where the truck was seized, he was multiple times in contact with that person with the fake SIM, and that mobile was seized. And on the day of his arrest, his house was raided, and at that raid time, 20 lakh rupees cash was found. So it is not that land was sold and then it come up. Because you see, if I have good friends, and 20 rupees is seized from my pocket, there'll be 20 people of you who will stand up and say that, well, 1 rupee I contributed today morning. We found him. We found him coming out of the embarking from a rickshaw. He couldn't pay 20 rupees to the rickshaw fare. So therefore, looking at the fate of Mr. So and so, we contributed 1 rupee each, and then that is how 20 rupees came to him. Correct. if you want to, this is not a joke. It's a part of litigation. You'll have to care to read the judgment of the J. Jayalalitha. There, what happened? Disproportionate asset case was charged against her, and she said that, well, I have reasons to say how my assets are disproportionate, and she said that in my birthday on so and so, thousands of people came and gave me gifts, and she listed 1,000 witnesses in her defense. I went to Supreme Court, and then Supreme Court said that, well, if it's a similar type of evidence you want to read evidence of 20 people. So that is the first case where an exception was carved out by the Supreme Court, saying that representative capacity evidence could be led. Correct. So,
That
so
is
what
the
else?
only
It's,
point
no, it's okay, but I'll go through it.
Yes, Just
Yes,
based on the
the-
length of detention, if you may consider.
Because it's the worth of drugs also. 50 crore is, I was not.
Yes, and your lordship, most importantly, the other accused who are also involved in this case, they are now out on bail, except this petition. All of them.
It's okay. Item 17,
Unless you.
but these orders would be uploaded only on Monday. Today it not be uploaded. I will not have time. By the time I finish, I will not have time to upload it.
Lordship, in this matter, we have not received the CD, Lordship.
Hmm?
We have not received the CD. Lordship.
Oh, pardon me, CD not received.
CD not received. Lordship.
Just 1 minute. But you'll have to get it. This is a bail application we have rejected earlier. Earlier bill was rejected when?
Earlier, rejected on 17/8/2020.
17/8.
17/8/2020.
You get it by 12th. Yeah, 10 days time, you get it. Because he may not be, he has done a mischief, but it's 4 months or 5 months, then we'll have to grant him bail. On both sides are represented. On the prayer made by Mr. I forgot the name again. Mr. K. Bashir and the APP. One further opportunity to grant to produce case diary is given. To stop this. Make clear that if case diary is not received on the next date of listing, the orders would be passed on the basis of materials available on record. List on 12/1/2024.
Applies.
আমি ঘুমিয়ে আসি
Yes, this item 14.
Says that there is no straight jacket formula, Lordship. So
No,
why?
no, but this, you see, there must be some what you call some guidelines. Because if a person is earning a salary of 58, would 22,500 be equitable?
20,
15 plus 7,500 is 22,500.
the thing that we considered is that there is a minor son also, who is studying in class 5 now. There is no suppression, full disclosure. Asset and liabilities was also disclosed. Supreme Court Lordship in Rajneesh versus Neha only has laid down some factors that are to be considered. Those factors, Lordship,
Rashish versus Neha.
yes,
Yes.
para 77, page 371.
Yes.
The objective of granting interim permanent alimony is to ensure that the dependent spouse is not reduced to destitution or vagrancy on account of the failure of the marriage and not as a punishment to the other spouse. There is no straitjacket formula for fixing the quantum of maintenance to be awarded. The factors which would weigh with the court inter alia are status of the parties, reasonable needs of the wife, and dependent children, whether the applicant is educated and professionally qualified, whether the applicant has any independent source of income, whether the income is sufficient to enable her to maintain the same standard of living as she was accustomed to in her matrimonial home, whether the applicant was employed prior to her marriage, whether she was working during the subsistence of the marriage, whether the wife was required to sacrifice their employment opportunities for nurturing the family, child rearing, and looking after adult members of the family, reasonable cost of litigation for a non-working wife. These factors are there. So Neha versus judgment, Rajni's judgment was also considered by the learned trial court. All these factors are there. Asset and liabilities was also considered. She is not a working lady and a child's future is also there. Child is now studying in class 5. Court has passed order for 15,000 taking into consideration all these factors. And another paragraph, Lordship, para number 60, Lordship, may kindly be pleased to come, Lordship.
Just a moment. Hindu laws.
এই রঙার উপর
এটা প্রিয় এটা অন করে বলি সাইটেশন 2018 5 SCC 333. This, I'll show you this judgment. This is by the Supreme Court of India, authored by a former Justice Abhay Manohar Sapre, formerly Chief Justice here. In this case, he has, through his words, the Supreme Court has laid down that orders under Section 24 would supersede orders passed under 125. I have not found any judgment which has overruled this. We'll come to this last part. B. Para 13. First, please, it will be second D. Go up. Secondly, no, not that. 9.2, second. You can read it. That's why I said 15. Well, at that time, I would not, I was not remembering this.
But Lordship, in my humble submission, Rajneesh versus Neha has considered all these factors regarding overlapping jurisdiction and past order.
This was never overruled.
Rajneesh versus Neha is 2021, 2 Supreme Court, 2 SCC 320.
No. This observation of the Supreme Court of India has not been overruled. You find out.
Lordship, may kindly see para 50 of Rajneesh versus Neha.
50.
50. 4 paragraphs I will take your Lordship. 50, 51, 60, 61.
Yes.
Section 26 of the DV Act provides that any relief available under section 18, 19, 20, 21, and 22 may also be sought in any legal proceeding before.
You see, that doesn't take me anywhere. You
Then-
see, because whenever you see, this is a judgment, Neha versus Rajneesh is authored by a judgment of 2-judge bench.
Judgment.
Correct.
Judgment.
Now, the judgment which I have shown you, that was Sanjay Sinha, that was again by a 2-judge bench. So a contrary decision can be per incurium, number one. And number two, it would not be a binding precedent unless it is specifically overruled. So therefore, you see any other observation, what you'll have to demonstrate is that the observations made in Sanjay Sinha is overruled. If it is not, a coordinated bench judgment would not be a good law. If you want an authority on the point, you will have to go to Mrs. Mazumdar sitting behind. She will show you the judgment of Pranay Sethi. She will have it with her. Pranay Sethi Constitution Bench says it has given a description in para 38 or 37, 38 that what is the principle of stare decisis. No, but this is Constitution, that's why it's more easier. Stare decisis is said there. And it says that the coordinate bench ought to have been ought to have followed the precedent. In Pranay Sethi, 5-judge bench, you will find in the middle of that judgment, 38, 37, I forgot. I've forgotten because I don't read now. That is why you see in the morning when in the first session, I said we cut down that 22,500 less 70,500, we said 15,000. This awakening came after my lunch break. There is another way of shortcutting it. I'll come to this judgment. this judgment of Rajneesh, if you have a copy, come to page 343.
Yes, sir.
You have come there.
Yes, sir.
Starting from serial number 15 at first page for 343, because this SEC gives citations in serially,
That I,
correct?
whether this judgment,
It's not there. Yeah, that's why I said I can shortcut it. You have this copy.
yes,
2018 is not even referred. Question of overruling will not come. 353 page. Index of cases. You take this copy.
I checked.
You take this from here.
I already have. I already,
You have it. Come to page 343.
yes,
First line is 15, serial 15. This is 2019, correct?
yes,
It goes in serial order. The case which I have cited, which is in display, is 2018 5 SCC.
yes,
So 2018 5 SCC is not even quoted here.
yes,
Sanjay Kumar Sinha,
yes,
correct? So question of overruling will not come. It's just a shortcut method. Instead of reading the entire thing, I go to this index. If cases is not cited, is not overruled. Simple theory.
but whether this ratio has been considered or not, that
That's what I said. In per incuriam, I'm using a word per incuriam. I'm cautiously using that word. We're taking full responsibility of what I'm saying.
yes,
If a earlier judgment has not been considered, for that principle, the earlier judgment will stand. Because here it says, you see, you read that again. Secondly,
yes,
very clear. It will supersede. And that is the law. When it says it supersedes, that means 125 cannot override section 24. And that is why my arithmetic was 22,500 less 7,500 will fetch you a maintenance of 15,000. Where is this 125 judgment of 125? Your son gets how much?
One in one
3,500,
7,500.
No,
3,500.
son is 3,500.
Yes, 3,500.
Then that part will stay. Then Mr. Khan, this 3,500 has to be added back to 15,000. You get a benefit of only 4,000 rupees. Agreed? So he gets the benefit of this 3,500 because 125 maintenance of the child is not added to the wife's maintenance. Okay, should I dispose it off? Okay, it will be reduced, but I'll pass on orders in the chambers. It will take me some time. I'm not detailing it here. Let me put it here. List on 12, Mr. A.M. Khan, counsel for the petitioner, and Mr. G.J. Sharma, counsel for the respondent. The arguments are concluded. List on 12, 1/20/24 for delivery of orders.
Much obliged. All right.
It will take me some time. I'll be able to. 18.5 SCC 353. 333. 2018. Okay. Chambers. 15. Deposit 50%.
Yes, Lord. We have a I also, I 9.
This is okay.
Yes.
This is R.D. Mazumdar, MSCT appeal. Admit call for the records, notice, steps, postal receipt track report. What is the date we are giving? 21/2. Stay subject to deposit of 50% with the registry of the court. Here also notice.
Yes. Highly obliged.
Time being item 11.
Yes.
My lord, your lordship's one initial order was passed on 17/11/2022. Just at a glance, I would like to take your lordship to page number 3 of that order, my lord. Which reveals the entire story of it. It starts from the learned counsel for the petitioner has paid for staying in further proceeding of the title suit number so and so, pending before the court of learned Mr. number 1, Dharam number. The case projected by the petitioner is that he is the plaintiff in the said suit, and the suit was filed for claiming preemptive right in respect of the suit grant described in the schedule B of the plan. It is further projected that the petitioner had cited the sub-registrar of Mangaldehi as his listed witness, and the same name of the said authority was also cited by the respondent number 1, defendant, as his witness. Then the senior sub-registrar Mangaldehi had appeared before the learned trial court as PW4, and his evidence in chief was recorded on 1/9/2018, and he had disclosed the name of the then sub-registrar who had registered the concerned.
I have got it. I have got it. Yes, you have to say anything, Mr. Chaudhary.
In this case, I have seen the PW4 was completed in the year 2018. And then it came to the knowledge of the petitioners that lordship, the volume book was not prepared, lordship. So after 2 years, they have filed the application for additional documents and all this, Lord.
No, but you see, if the document is not there, let us say that he has filed an application 2 years earlier. How does it change the situation?
But first of all, lordship, whether these documents are required, lordship.
No, the answer is very simple. You make a statement, we record it, that you will not take an objection in the trial court.
That lordship.
No, that's what I say. Answers are easily available. It is just acceptance of the answer.
Lordship, after 2 years, then petition was filed, PW4 complete, PW5 complete.
That's okay, but you see, if the document is not registered in the volume, what to do? You suggest an answer that this could be a plausible answer.
No, lordship, they have filed RTI, lordship, when it is within their knowledge in the year 2018, lordship. Immediately, they have not filed any RTI.
No, you see, you see, there are certain things we don't do always. You see, I'm sitting in a chamber where I get so many informations. People come with what you call people call upon for something. People have some genuine issues which they don't want to speak out in the courtroom, and I am the one accessible to the bar. Correct. I have not insulated myself. I am accessible to the bar, so we get information. Now you see, for example, take this district of Kamrup Metropolitan Guwahati. Here for last few days, sale deeds are not being registered. Correct. Now I am told that the ADC is himself taking up the matters here, listing 20 cases, and then they are registering it serially. This is just the information from the bar.
Token system basis.
Huh?
On a token system basis.
On a token system basis, okay. This is something addition to my earlier information. No, now you see, people don't come to it because of their, it's their profession. Lawyers think that if they go, maybe the officers will be antagonized. They may not be, what you call, doing their work. So therefore they don't protest at times. And in the trial court, if this has happened, you see, had it been that the records are available and he has what you call not acted diligently, then it is one thing. Otherwise, you give a suggestion that in such cases, what can be done?
That the application was filed by the petitioners under order lottery. Your lordship will find that the learned trial court, while rejecting their petition, has elaborately discussed everything, your lordship. Their petition was filed under order 7, rule 14(3). The learned trial court says that the lordship, this specific rule is not applicable in this petition, lordship. And one more prayer was to take judicial notice of those documents, lordship. That was also answered by the learned trial court. And section 151 of CPC, that was also answered by the learned trial court, that when there is a specific provisions, lordship, 151 is not applicable. And your lordship decision is also there of this high court, lordship. That if there is specific provision is there in the CPC itself, that lordship, we cannot take the benefit of section 151. So all these grounds were clearly stated by the learned trial court. So lordship, in my humble submission, I have not found any irregularity in the order itself, lordship. May my senior learned English counsel submit first, lordship, then I will reply. Whether there is any irregularity or lordship illegality in the order itself, lordship.
No, you see, the effect of this order, if I have read it correctly, is that the legality of the sale deed itself is under question, as it was not entered in the volume book. Now, the Registration Act says,
Right of preemption.
no,
Plaintiff's case is for right of preemption.
no, but for preemption, he is wanting to annul that sale deed,
Lordship.
which is not entered into the record, right?
Our case is that, lordship, the right, the sale deed, though executed, it was not still, lordship, entered into the volume book. So it is not completed, and the one condition for right of preemption.
You see, I have not been able to express myself. You see, what happens is that the original sale deed has to be called for by the court and then annulled, even in the case of preemption. When a sale deed has to be annulled, the orders of the court is that this sale deed be brought to the court and sent to the registrar office to have it cancelled. So the physical document is required for cancellation. Now, assuming that in this case, what has happened, I don't know, but assuming that the original is not there, and therefore, what happens is that in the cancellation of the sale deed will be recorded in the volume book. They will mark it with red pen.
This is not the case, lordship. PW completed.
No. How does the cancel? My question is, how is the sale deed, cancellation of sale deed recorded? Cancellation of the sale deed is recorded only by calling for the original, because if he's claiming right of preemption, that means he's challenging sale of the land to another. correct? So I'm presupposing those, and therefore if the land has been transferred, there has to be a sale deed. Now registration of a sale deed is only complete when it is entered into the volume book. But that is the law. The Registration Act says so. So unless it is registered, the expression registration is not complete. Correct? Any difficulty there till there? No. So now if that original document is not produced, there are two conditions. Number one, original documents are produced, the registrar will mark it with red pen, say cancelled. And that cancellation will be entered into the volume book. Now, if the original document is not there, the cancellation is recorded in the volume book with that mark that by order of the court so and so marked, and the note is given, signed by the registrar, sub-registrar. It is signed. That is the procedure. Am I wrong there? Now, if that volume book itself is not there, how is this registration complete and how will the cancellation of sale deed be registered? That is the question. Now you forget about the provisions of law, we'll come to it later. Because because you see, there's always another way, and that says that procedure is merely a handmaid of justice. So if a practical thing is that the sale deed is to be bought in and have it registered and the volume book is not registered, then what to be done? Then the second is that the second option that the sale deed which is created at a particular date of time has been digitally entered in the records. Was it done? Then how will this annulment, how the court decree will be passed? That is the only question I'm asking for the time being.
Lordship, their right of preemption, they have claimed, and we have objected that, Lordship, that till date, the sale deed was not entered into the volume book. So their right is premature, Lordship. That is one of the objection by the defendant number one, who purchased the plot of land, Lordship.
Then it is easy. You are giving things in a platter.
Lordship. So, Lordship.
You understand the implication?
They have called senior sub-registrar, Lordship, he adduced.
No, not that.
he was
You see,
cross-examined.
if that is the point and you stick to it, even in the revision.
This is one of the.
No,
ground,
then you see the implication is that the registration is not complete.
Lordship.
So you see, the right of preemption will still run, will still operate. You see, these parties, they are Mohammedan,
Yes,
Yes.
correct?
Yes.
Now, under your Mohammedan law, how is the transfer, irrespective of the what you call this execution of sale deed? How under the Mohammedan law it is acceptable that if it is announced, correct? On announcement by the vendor in front of the people that he has sold it to so and so. So that word of mouth itself is a acknowledgement of sale. So then tell me, under the Mohammedan law, why this suit of preemption would not be would not lie? It's a legal requirement that any section 17 C, any document 100, more than 100 has to be registered.
Yes. As per section 49 also, my lord.
Huh?
Section 49 of the registration.
That is not in evidence. That is not to be read in evidence. 49 is something else, not to be read in evidence. But there are judgments of this court as well as Supreme Court of India where it has been interpreted that unless it is entered into the volume, the registration is not complete.
That was also cited by the trial court also, Lordship. Their prayer was, Lordship, that is as per under order 7, rule 14, Lordship. To take prayer portion, I will take your Lordship to the prayer portion, page 144. Under the facts and circumstances cited above, it is therefore prayed that your honor may graciously be pleased to accept this application and be further pleased to grant leave to the plaintiff to file, introduce the documents received through RTI and filed along with this application as annexure 1 to 3.
No, I will come to it. I'm still now not on the facts. I'm still on the Mohammedan law. You see, right of preemption, please come to this Mullah's Mohammedan law. Right of preemption. it shall also arise when intention to part with the possession is done. It's not necessary that sale deed has to be executed. When somebody comes to know that he is planning to sell it, then also the right of preemption can be invoked by Mohammedan. What is the provision? I forgot those provisions.
My lord, it is first demand is talbe muattaba.
Here in this book, which provision? Section?
230.
My lord,
I'm having mullah.
I am having Faizi, my lord.
Oh.
Faizi. Mullah is section wise given, my lord,
Huh.
but as the law is not codified. So simply for the purpose of reading Mullah.
But where will I get it?
137,
Well, I have this book. I don't have that.
220, I think, ma'am.
230 onwards, Lordship, that is.
Two?
Mullah. 230, Lordship.
230.
To 30.
Page 205, Lordship. Starts from 226, chapter 13, Lordship.
Because you have an advantage of Muslim law university. Since I am I'm a local fish. I have access only to mullahs.
My lord, that contents are all the same.
Huh?
Contents are all the same.
No, it's okay.
The law laid down is also same, my lord.
I'm just making your mood lighter. Nothing more. Preemption.
Speaks about only 3 demands that your lordship will put in special over here.
Oh no, then she's right. No, Mrs. Satar, then I'll have to agree with her. If the sale deed is not registered,
CLD is registered, my lord,
no. You see,
but not reduced into writing in the volume book.
no, that's okay. So registration is not complete.
So in that way,
Sale is
registration
not
is not complete.
Registration is not complete.
Not complete. Now, the
Uh,
reason is shown by the PW4. The reason is shown by PW4. And that your lordship has also mentioned in the.
In the order, yes, I've seen
Yes.
that.
Page number 4 of your lordship's order, last paragraph.
No, but in this right of Shufa, 226 here in the Mullah, it says the right of Shufa or preemption is a right which the owner of an immovable property possesses to acquire by purchase another immovable property which has been sold to another person. Come to 54, what does it say? Sale is a transfer of ownership in a exchange for a price paid or promised, or part paid and part promised. Sale how made? Tangible 100 in orders, resolutions can be a registered instrument. So if the
Above 100, the registration is mandatory, then registration act will come, Lordship. And according.
and
to
registration act will say again, 54 that sale, the registered agreement, registration is not complete unless it is entered in the volume book.
Yes.
So therefore sale is not complete. The first requirement of Shufa is not concluded.
Reason is shown by PW4, my lord.
What is that?
My lord, that your lordship has also mentioned. At page number 4 of your lordship's order mentioned in page 211.
PW4 is annexed, Lordship, and the statement of PW4 cross examination was also annexed, Lordship, can see from that also, Lordship.
May I read that part, my lord? Page number 4.
Yes.
My lord, it is projected that the manual copying of the registered deeds in volume books was stopped since 31/12/2003. And that since 1/1/2012, the registered deeds are stored in computer storage, and that the computerization work of registered deed backlog on and from 1/1/2004 to 31/12/2011 are under process. So there is no question of after 1/1/2012, my lord. After, not after 1/1, but after 31/12/2003, my lord, there is no question of reducing any sale deed into the volume book. Because
No, no, no.
computer system
You
can-
see, under the digital recording which has been done, there it is taken off, it has been addressed. That becomes now a volume book. Auto, what you call generated, what you call digital copies
My lord,
is digitally entered in the volume book.
my lord. So, my lord, the sale deed which was stopped copying in the volume book from 31/12/2003, and if it is stored in the electronic media, my lord, that is endorsed. And the sale deed is only of the year 2006, which is in question. So sale is complete, my lord.
No, whether it is entered or not.
That is the backlog. That's why, my lord, we want to brought that before the learned trial court. But the learned trial court has made the observation that is redundant, not necessary. If I can take your lordship to page number 172. That is the last operative part of the impugn order, my lord. It starts from 171, my lord, after the dissertations made of the judgments, my lord. 171. In view of the above legal position relating to non-copying of the sale deed in the respective volume books maintained by the sub-registrar office and its consequent legal status of non-completion of a valid sale, any reason shown by the plaintiff or any sort of evidence to that effect would be of no consequence at all. Because whatever may be the reason of non-copying, irrespective of the fact that whether the plaintiff had any fault or not, whether the plaintiff had any control over the affairs of the estate or not, the status will remain the same to the effect that the sale was not valid as per law. Sale was not valid as per law.
But then why you are in court? She should be in court.
She should have been in court, but I am in court because of the fact, my lord, that this gentleman has been, Apurva Kumar Nath has been cited as the witness from both the sides. Now DW1 is started. Now he has not been called as of date by taking recourse to order 16, my lord. That's why I am before your lordship. Now furthermore, my lord, one more, paragraph I would like to just apprise your lordship. It may sound harsh, but the law has to be treated as such, which has been clarified by the Honorable Supreme Court of India itself. Then, my lord, considering the above factual background, materials on record, and also due to the reasons as noted above, I am of the view that allowing the prayer of the petitioner, plaintiff, will be nothing but a mere futile exercise. I do not find any cogent reason to allow the petition filed by the petitioner, plaintiff, petition number such and such is rejected accordingly. So this part of the order, my lord, is in excess of jurisdiction because it has given the finality before deciding the suit.
No, that may not be. Because he has given a finding that it's not registered. So it's not a proper sale. So I think the beneficiary of the sale deed should have been before the court,
Yes.
saying that without trial, how can the sale deed be annulled?
But my lord, that's why the volume book is a different aspect, and the computerization and taking into account of those backlogs is a different aspect. According to my submission, my lord, once it is brought to the notice of the sub-registrar by way of electronic media, then it is a complete sale. And that was done in the year 2006, because from 31/12/2003, that while reducing the deeds into the volume book was stopped. And it was taken note of in the electronic form.
No, no, just tell me simply, now, as per your information, whether it is digitized or not.
According to my information, my lord, it is lying in the court. Original is lying in the court.
Still it is lying in the court.
Right.
So therefore, question of registration will never come.
No, after 31/12/2000,
No.
my lord,
They will digitize what? A document which is available with them.
yes.
If the original is not with them, they can't digitize.
My lord, till 2012, it was there with them. Till 2012, it was there with them because my shoot was filed only in the year
2000?
2012. 2012, my lord.
No, but this digitization, you see, they've stopped it from
31/12/2003, my lord.
31/12/2003 to 11.
My lord, your lordship observation, page number 4, last line of the first paragraph.
Yes, so 2011.
Yes,
So since 2012, it is in what do you call, in the court. So whether they have done it or not, you can't say for sure today.
we brought it only after filing of this shoot, my lord, by calling that deed upon which the PW4 has been examined. She said that at that time I was not there, it was Mr. Apurva Kumar who conveyed us.
No. You see, after a deed is registered and entered into the volume, when the deed is registered, they are written in the first page.
True, ma'am.
And the back pages contain only the seal
Yes.
of the authentication of the sub-registry that it has been registered. Correct? In the back page of first page, these thumb impressions are taken. Those signatures are there.
Yes.
Now, if the document is entered into the volume book, in the last page, there will be an endorsement with a stamp that entered into volume book number so-and-so, so-and-so,
Pages.
pages number so-and-so,
Yes.
that is registered.
Yes.
So in the original, if it is not there, it has not been registered, that means.
No,
Even after digitization, those are entered. A digitized record,
yes.
after being entered into digitized volume book, that entry is always made.
No, it is, volume book is, my lord, totally stopped. So from.
No,
which
that
page to
digitized
which-
record itself is a volume now.
Yes, yes, true. That is the book number 1, volume number 1.
No, I don't know that. This digitized record is also a volume.
True,
Correct.
correct.
Now, if in your original which has been called, if that entry is not made, entered into the volume, they will say digitized volume so and so. That entry will be there. Has to be there.
That part, my lord, we have not seen whether that entry is there on the last page of the.
Has to be there. Digitized. They will say digitized. Say, Mr. Jain.
From the same deed, they will give one slip, the last part of the deed. That this has been.
Registered and entered, digitized volume entered. See.
So that must have.
2014 letter says it has not
So, my
been
lord-
Huh?
entered in the page 85, your lordship kindly see. Annexure-
85. Thank you, Mr. Jain. No, that's all.
Annexure 8, lordship. Last 2 lines, lordship.
For copying in the volume.
Yes,
It's okay.
still it was not entered in the volume book.
Correct. You're right.
This letter is of the year 2014.
14.
So from 16, it is lying here in the court. Where is your petition which has been rejected?
My lord, it is at page number
174 it starts.
138 to 149.
One
Petition.
130
petition.
My petition, my lord.
Yes.
Yeah, 138 to 149.
138. What is your RTI document?
RTI document, my lord, is at page number, RTI application is page number 135, and RTI, my lord, letter is at page number 136.
136.
36, 137, both. Application. 35 is the RTI application, my lord. And the report is, research report is 137, my lord. Dated 4/3/2020.
Now, how does this, on the page 136, how does it help you?
137, my lord.
136. You said 136 is the RTI reply.
No, 137 is the RTI reply. There was a notice given to me to be present.
Mr. Jyoti, this has to be allowed. You see, what do you call it? He has got a reply. A document has not been entered into the volume. Whatever be the reasons, that the court will decide at the merit. How can now it be prejudged that whether this sale deed is not, how can the trial court now say merely because it is not reduced in the volume, sale deed is not registered?
From the document itself, it can be presumed that lordship, it was not entered in the volume book. Their contention is that lordship, as this search report says, it was backlogged, it was stopped since 2013. Had it been entered in the volume book in right time, lordship, the sale would have been completed, lordship. That is.
No. You see, that is, we are presupposing what they will do. Today, the application is that we have a search report which says that from period so and so, sale deeds are reduced in the volume, so and so are backlog, and so are not, what you call, is yet to be completed. Only 3 part. That is given by the sub-registrar. Now, what would happen with that is something for the court to decide at the trial. How can we start examining the merit of our evidence today? Therefore, you see, everybody will come. No, not that. You say, so then tomorrow what will happen is that X is a plaintiff. He cites A as witness. Somebody will come and question that what will A do? He does not know anything. He lives 2 kilometers away. What he will come and do in evidence? But this is something to be adjudged only when we at the trial. You see, how can we permit this observation to remain, which is though against you? That it has not been, the sale deed is not valid. You are happy with that?
That I have not challenged, lordship.
No, that you have not challenged, that is one part. And you know, let me tell you, these are the words which are used by the Supreme Court in its judgment. It's not something which I am uttering. It says in certain cases, mistakes are purchased.
Mistakes are, my lord.
Purchased. Correct. I won't comment because I don't know the meaning of it, but it's just a statement which I am reproducing. Now, what happens is that a deed is not entered. You are happy because you are in possession. You got nothing to worry. The amount of delay whichever occurs is in your favor. But one who is claiming preemption, he knows that there is a sale deed. Everybody knows that there is a sale deed. Sale deed is in existence before the court. And the registration of the volume is not there. And that apart, the trial court writes in the order, the sale deed is not valid. If the sale deed is not valid, please tell me how will he exercise his right of preemption? Somebody has come into possession. Therefore, what I do is that I purchase a mistake. Sale deed is registered. I enter into the house. What happens in a ejectment case where somebody sublets?
Like, Lordship, by these documents, they wanted to show that still those were not entered into the volume book. These are the.
No, what they want to show is something, leave it to Mr. Satar. What, you see, if I start thinking in that manner, I'll not be able to pass a judgment in a year. Because then I'll sit back thinking, oh, my order, what will happen? This will happen with my order. Tomorrow that may happen with my order.
Lordship, there is no illegality in the order in page 161, in my opinion, Lordship, my submission that page 169, the learned trial court already held, Lordship, last paragraph, there is no plausible explanation on the part of the petitioner as to why no petition was filed expeditiously if there was necessity to call another official witness. Already senior sub-registrar was, Lordship, called, he was examined, Lordship.
The trial court does not know how to write an order. I'll tell you why. You see, when an official witness is called, there may be two ways of calling him. Number one, to produce a document. He's called under Order 6 Rule 16 only to produce a document. And number two is that he's asked to give evidence. Now he'll give an evidence if a sub-registrar office clerk comes and officer comes to give evidence. He will give evidence only based on the volume book. Correct. So what do you write in the requisition slip? The court will write in the requisition slip. You come to this so and so. You are directed to come to the court with so and so volume book, and to give evidence to that in respect of that. That is the requisition sent. Now, please tell me, if I have not issued a requisition as a court, supposing I am a Munsif, I have not given a requisition to bring the non-registration proof. Will the officer come and depose to that effect? He will say, I don't know.
Lordship, the original sale deed was called and he.
Now we are beyond sale deed. Now we are in the completion of registration process of sale deed. You have accepted the sale deed is not there. So don't worry about it. Sale deed is not there. The order is that sale deed is invalid. So your title goes. So you are not affected by it. We are also happy with it. Correct. One less trouble for the court. That is one part. You forget that sale deed. Now what happens if it is not registered? How will he, 223 Shufa, how he can claim the right? And then second is that can you be permitted? Because you see, we have many ways to deal with it. Number one, we can invoke the provision of escheat and say in the court that if there is no owner of the land, the seller has sold the land. He has dispossessed himself of the ownership. And number two, sale is not completed, it is invalid. Therefore, state will be directed to invoke the doctrine of escheat. You know the doctrine of escheat.
But it does not.
If there is no owner, Sarkar is the owner.
It does not say that it is invalid. It only says it has not been completed yet. So, Lordship, right of.
No, invalid.
Valid.
Invalid.
Not valid sale as per.
Not valid as per law.
It has to be completed, then right of preemption.
We don't know. You see, either there is a sale deed or there is no sale deed. If there is a sale deed and it has come to the court, produced by the sub-registrar, sale deed is there. Now the registration is not complete. That is two different things. Sale means that, that's what I'm asking you. Now, whether you claim that the vendor of yours still retains a right,
He has already executed, Lordship.
he is executed and gone, you are admitting that the sale is not complete. If sale is not complete, there is no owner of the land. We direct the state government. Mr. Bhattacharya is here. He is very happy. Let the state government get that property. As simple as that. We direct them to, for ends of justice, we ask the state to examine. If there is no owner, apply a doctrine of escheat.
It was appointed only to that period, Lordship. It is still not completed, Lordship. After completion.
No,
we
but you
can
see,
review the-
I will not permit a suit to be stayed for that. Let us say the government comes up with a plan, 5-year plan, and the registrar comes before the court and says that, Lordship, we have a 5-year plan. The deed of 2012 will be registered only 5 years from today. Let us say 5-year plan they gave. Now, what should the court do? Suit will be stalled. Then we'll have to say that this suit will be stalled till the volume is registered. Can that be permissible? So either there is an existence of a document or there is no existence. You'll have to take one stand. Whether the document exists. If it is not, you see, we have many handle. Number one, you come to order 13, what is that? Impounding of document, order 13 to P. Impounding of document, correct. Second, even in criminal procedure, you have impounding of document. The impounding of document is there in the civil procedure code. Now, if the document itself is not is an invalid document, why the district registrar should not be asked to impound the document and keep it? Because if it's an invalid document, there is a court order already declaring it to be invalid. Why it should not be an invalid document? Why should it remain on board? Why it should not be ordered to be impounded? Why a fake document will remain in?
In the process, Lordship.
Oh, that's why I'm saying you take a stand.
Right, the heading is production, impounding and return of the product settlement.
Huh?
Product settlement.
We were your good students.
My lord, and my prayer, my lord, by my prayer, making the prayer, no way they are prejudiced. They have ample opportunity to contest.
No, because the court can't give a prejudgment before a trial. Court cannot say it is invalid. Rather, you should have been here. I'm surprised that the owner of the property doesn't come to court challenge that the sale deed is invalid. Rather, you are accepting that it is invalid. You are accepting it. And you're opening other ways. You see, doctrinal cheat, where is that? ATP Act. Is cheat here or in the Succession Act? Where is it? TP Act or cheat? It will be succession. I think it will be in succession. Transfer of property, I'm wrong.
My lord, under the Hindu Succession Act, section 29, man,
29 succession.
section 29 of the Hindu Succession Act, my lord, 1956, is chief, the word is chief.
One of the judgment of Supreme Court, Kachi Lal Rameshwar Ashram. The principle the law does not readily accept a claim to a cheat, and the onus rests heavily on the person who asserts that an individual has died intestate, leaving no legal heir qualified to succeed to the property, is found on a sound rationale. Escheat is a doctrine which recognizes the state as a paramount sovereign, in whom property would vest only upon clear and established case of failure of heirs. So if valid transfer right is not transferred by a sale deed, and the property is divested by the owner,
Then property devolves on the government, it is written, my lord. Then the property devolves on the government, here it is.
no, Mr. Chaudhary will allow this. It can't be permitted. What is the intent of a witness if the court starts to prejudge? Then tomorrow we'll have cases where somebody will come, why B has been cited as witness, why D has been cited as witness? What will he come and do?
That would be additional evidence they can deduce, but they have cited order 7 rule.
Those
14.
things, court can always, handbridge of justice, provisions court can always mold it.
Court also, Lordship, answered the provisions in that way that
Let's see
order
that.
7 rule 14 is
see
not
that.
applicable and 151 is not applicable.
We'll take care of it.
Court is not required to take judicial notice, Lordship. They can deduce additional evidence.
No, court will not take judicial notice of it because of section 57. You see, in 57, there are 13 subsections.
That was their prayer, Lordship.
No, it's
So
okay,
that
but
was
that
answered.
is something which the court cannot take unless it is there. But if our authority comes and says that I am not registering it, first example when I gave that these 20 salaries are being registered, if the government comes with a notification and says that, well, we have stopped it, end of the matter. Otherwise, tomorrow you have a right to come to court and say that, well, 20 sale deeds are being registered in Guwahati, where there are every day 200 registered. I lose my professional practice. Your right to livelihood, Article 21, you invoke it, and then you get an order.
Section 57, order 7, rule 14, all are answered by the trial court, Lordship. Their prayer ought to have been under order 41, rule 27, Lordship.
Which one?
Reducing- Order 41, rule 27, reducing additional evidence, Lordship.
This is an appeal.
Title.
In Title 41 will not come. In then 41 will not come. There is only evidence by way of what we call order.
Addition,
Huh?
Lordship. That order 7.
Order 16.
is not applicable. That was answered,
It will be only under order 16.
Lordship.
Ah.
And on that ground only the learned trial court answered, Lordship, that order.
No, but it
6
gave a reason. You see, it says that what situation not change. It will change or not, that is something which I think it will be best left to Mr. Sitar to show it. You see, people who have seen me in trial court would tell you that I was notorious in asking questions to the witnesses. Correct. Mr. Sitar was the same. We have Mr. Talukdar, same. Mr. Jain was very decent. Next to him, Mr. Gaur, he's also decent. But we were not appreciated at our times when we cross-examined. Because the answer will come only in the last. You can't ask the question direct.
After letting the witness, then when the real question, real answer comes.
Yeah, as stalwarts. We have seen magistrates being examined in court and crying. There's one incident in additional session judge where a magistrate ended up crying. His senior law is no longer there. No name him. We have not had a share of experiences. How can the court understand what is the what is that provision, Mr. Pratap, Order 16? Okay, additional evidence, Order 7, Rule 14, is it? No, Order 7, Rule 14, is it? Evidence Act. Evidence Act. Evidence Act. Yes, Mr. Star, what provision would be there?
Order 16. And take the lordship to order 16.
I'm there at 16. No, evidence which is not produced.
My lord, for that, my lord, there are two provisions. Order 7 Rule 14. So 14.3 says for the purpose of refreshing the memory. Similarly, my lord, Order 8 Rule 1A 3 also speaks about the same.
Order 8 Rule 1A.
Yes, sir. Order 8, my lord, it goes like this. Similar provisions are for the plaintiff.
Oh, that is for the defendant.
As well as for the.
You are a defendant.
Yes,
You are the
no, I am
plaintiff.
the plaintiff.
You're the plaintiff. So Order 8 will not come.
But in both the word plaintiff is used, that is clarified subsequently in the Salem Bar Association case. My lord. My lord, 3 is a document which ought to be produced in court by the plaintiff when the plaint is presented, or to be entered in the list to be added or annexed to the plaint, but is not produced or entered accordingly, shall not without the leave of the court be received in evidence on his behalf at the hearing of the suit. Nothing in this sub-rule shall apply to document produced for the cross-examination of the plaintiff's witness or handed over to a witness merely to refresh his memory. This is the for the plaintiff.
So leave of the court is 3.
Three.
That's what I'm asking. In this order, how that has been dealt with? Order 14, order 7, rule 14. Is impugn order, how this order 7, rule 13, 14 has been dealt with? Mr. Chaudhary had just read it. 168, yes.
Second paragraph. So far, the invoking of order 6.14.1 is concerned. The same is applicable in respect of documents which ought to be produced at the time of presentation of plaintiff. But in this case, the plaintiff has sought to produce some documents which has been.
Okay, I've got it. Just let me count it. Heard Mr. A. Sattar, learned counsel for the petitioner, and Mrs. R. Chaudhary, learned counsel for the
Respondent number 1.
respondent number 1. None appears on call for the other respondents. Next paragraph. By filing this application under Article 227 of the Constitution of India, the petitioner has assailed the order dated 29/6/2022, passed by the learned Munsif number 1, Darang Mangalday. Give a second bracket. Sorry, first, second bracket. Now renamed as civil judge within bracket junior division, bracket was number 1, Darang Mangalday. In TS number 32 of 2013, full stop. By the said order, application of the petitioner, who is the plaintiff, under order 7, rule 14 within bracket 3, read with section 151 CPC and section 57 of the Evidence Act, which was registered as petition number 2553 of 2020, dated 18/12/2020, was rejected. Next paragraph. In brief, the case of the petitioner plaintiff is that he had filed a suit being TS 22 of 2012, renumbered as TS 32 of 2013, seeking preemptory, PREMPTORY, preemptory right under Mohammedan law, under the principles of Mohammedan law, in respect of particular plot of land described in the schedule of the plaint. Full stop. The petitioner claims that he is the, inverted commas, Shafei, SHAFEI dash small a dash Sharik SHARIK in respect of the suit property. And accordingly, Mrs. Chaudhary, I'm asking you something. Uh, uh, I was saying,
Okay, so here's the check is week in respect to suit property and accordingly.
uh, according to the suit was filed, comma,
Lordship, permit me, I take one.
yes, yes. Interview for preemption, opposition and declaratory decree. And further consequential orders. Full stop. The respondent defendant had contested the suit by filing written statement. So in course of time, issues were framed and when the trial began and the petitioner side had examined 4 PWs. Full stop. The PW number 4
Madhavi Kolisa, my lord.
okay, because in page 100 you have not given that name.
My lord, from 94 to 119.
No, page 100, I'm there at page 100, it doesn't have that name.
Page 90. Page 95, my lord, reflects her name, the Madhavi Kolisa.
But the original suit doesn't have 108. Doesn't have. Hmm? Which page?
My lord, page number 104 starts, it starts, and that is the 108 is the continuation.
Oh, acha, acha. Okay. I missed out that. Okay. PW4, one Miss Srimati Madhavi, MADHABI, Kalita, was the senior sub-registrar. Mangalde. Where is that part?
Regarding the name of,
No, that original sale deed was not entered in the volume book. Exhibit A5, page 98. Specific deed has not been copied in volume book. This refers to which deed? Huh? So Mr. had stated,
what is used by law endorse?
had stated in her
Page number 110, handwritten, my lord. The word is used, the said deed number 2283 was called by this court, hence the contents of the same are not endorsed in the volume book, which is called for.
it's okay, that's not entered, this what is written endorsed in the volume book, which is called this is examination in chief or cross examination? In examination in chief had stated that as the sale deed number 2283 was called for by this court, as the sale deed number 2283 was called by this court, hence the contents of the same are not endorsed in the volume book, which is called for by the summons issued to me. Full stop, inverted comma closed. Full stop. Thereafter, the petitioner submitted an RTI query. The SPIO, Office of the Deputy Commissioner, Darang Mangalde, dated 10/1/2020, and in response to the same, the along with the RTI reply, the petitioner claims to have been provided with a search report bearing number DRD/07/2019/68, dated 4/3/2020, the green flag, page 137. First of the search report is as follows. I do copy the full stop. Next paragraph. In view of the the learned counsel for the petitioner has submitted that in view of above, having seen that the original sale deed number 2283 had not been entered into the volume book, which would mean that within the meaning of the Registration Act, 1908, the registration of the registered document is not complete. So hence, it is submitted that the petitioner had filed an application under Order 6 Rule 14, 7 Rule 14(3), read with Section 151 CPC and Section 57 of the Evidence Act, seeking leave of the court to file certain documents received through RTI. First of all, the learned trial court by implied order dated 29/6/2022, had rejected this said application. Full stop. Next paragraph. Submitting in favor of the impugn order, comma, the learned counsel for the respondents had submitted that there is no infirmity in the impugn order, and therefore, as there is no jurisdictional error, comma, the same ought not to be interfered with. So it is submitted that the court had given reasons for each of the provisions under which application was made by addressing the provisions of Order 7, Rule 14 within bracket 3 CPC, comma, Section 151 CPC, as well as Section 57 of the Evidence Act. First one. It is also submitted that the 5 PWs were examined over a long period of time from 3/11/2018 to thirteen to 2020, when the suit was fixed for further examination of DW1. And at a belated stage, the said application was filed. On 18/12/2020. So accordingly, she opposes the prayer. Next paragraph. It appears to the court that that in the present case in hand, comma, a unique fact situation has emerged. Full stop. It is not in dispute that a sale deed in respect of the suit land was executed and registered as deed number 2283 dated
2011-2006.
2011-2006.
Yes.
Full stop. Registration Act, na? Registration Act. Where is that provision?
Section 52, man.
52. Huh. And which provision? 61. Yes. So, execution of a sale deed is a document within the which is envisaged under the provisions of Section 54 of the Transfer of Property Act. So, under Section 52 of the Registration Act, it's a duty cast on the registering officer when a document is presented for registration, comma, amongst others, comma, to have it copied, comma, without any unnecessary delay, comma, in the book appropriated therefore, REFOR, according to the order of its admission. Full stop. As per the provision of Section 60 of the Registration Act, comma, after compliance of the provisions of Section 34, 35, 58, and 59, comma, an endorsement is required to be made containing the word inverted commas registered, together with the number and page of the book in which the document has been copied. Full stop. As per the provisions of Section 61 of the Registration Act, 61 within bracket 2 of the Registration Act, comma, a registration of a document shall be deemed to be completed only on compliance of the other requirements as well as the making of endorsement and certificate referred to and mentioned in subsection 1 of Section 61. And thereafter, the original document is required to be returned by whom he was presented. Next paragraph. Therefore, from the provisions referred above, comma, it appears that the registration of a document is completed only after it is entered into in the volume books. Full stop. In the present case in hand, the sale deed number 2283 dated 2011-2006, comma, has admittedly not been registered, entered into the volume books. As per the RTI reply, comma, manual copy of registered deeds in volume books was stopped since 31/12/2003. And the backlog of computerization of those records from 1/1/2004 to 31/12/2011 are under process which is not yet completed. So therefore, this would include the registered deed which is in issue in the present case, by which land is transferred to the defendants and to the respondent defendants, and the petitioner claims preemptory right. Full stop. Next para. The other situation which is observed is that assuming that the sale is not, the sale deed is registered, and the sale and the registration is not yet completed, comma, in this case about 19 years. 19 years now, right? 19 years now. Comma, would such delay in the of registering, sorry, and entering a sale deed in the volume book would extend the period of limitation to challenge sale by way of a presumption, preemption. Full stop. Full stop. In this regard, if we consider the provisions of illustration E of section 114 of the Evidence Act, comma, there is a presumption that all official works are duly done. Full stop. Therefore, here is a case where a sale deed has been executed. The original sale deed has been brought from the custody of the sub-registrar's office to the court in connection with summons issued to the PW4, and yet the trial court is of the opinion in the impugn order that that inverted commas, that the sale was not valid as per law, inverted comma closed. So therefore, it appears to this court that even before the trial, comma, judgment as to the legality of the sale deed is already on board. Stop. The court notices with surprise that the respondents have not come forward to challenge the order. Next para, be that as it may, comma, under such circumstances, when the petitioner plaintiff has come to know about non-registration only when the PW4 was examined, comma, the query of the court would be whether this is a fact which the plaintiff would have known before filing of the suit. Full stop. To the said query of the court, comma, the only answer would be that a person who is interested in a property would have notice of execution of a sale deed, but whether it has been reduced or entered in the volume book would not be within his knowledge. Full stop. Therefore, as nothing has been brought to the notice of the court, that only from on and from the date when the registration is complete, comma, right to sue would accrue. The court is of the considered opinion that a subsequent knowledge of events which are not available with the petitioner would entitle him to present an application to call for the to call for a document which was not available when the suit was filed. First off, this is merely an observation and not a conclusive finding of the court. Because in connection with this application under Article 227 of the Constitution of India, the court is not exercising appellate jurisdiction. And therefore, the court is not commenting on the legality of the document or the the validity of a sale. First off, the limited concern is only to examine whether the non-registration, non-entering of the sale deed in the volume book was something which was diligent, of which diligence was required on in respect of the plaintiff before filing of a suit. So to that limited query, to that limited question, the answer of the court would be that it was not required of a plaintiff to have due diligence as to whether the sub-registrar's office has entered a sale deed in a volume book or not. Under under such circumstances, court finds that the reasons assigned by the learned trial court in rejecting the application under in question, which is petition number. What is that petition number? It will be
Petition number 2553, madam.
2553,
Dated 18/12,
dated 18/12
2020.
to 2020. Full stop. Next, therefore, the court is unable to concur with the legality of that part of the order, that part of the impugn order, wherein the learned trial court had rejected the invocation of Order 7, Rule 14 within bracket 1, CPC. Because of the fact that the application was made not under Order 7, Rule 14.1, but it was under Order 14, Rule 7, Order 7, Rule 14.3, which permits the court to grant leave to receive document and evidence which were not presented when the suit was filed. Full stop. Assuming that, next para, assuming that there's the provision of order under the unique facts of this case, even if it is assumed that the plaintiff or the petitioner plaintiff ought to have filed the said document at the time of presentation of plaint, the court is satisfied with the explanation tendered that the non-registration of the non-entering of the sale deed in the volume book came to the notice of the petitioner only when PW4 is examined. From the said date, the document regarding non-registration, non-entering of the sale deed in the volume book would be a subsequent event. And therefore, even if the provision of orders 7 rule 14 within bracket 3 is not applicable, comma, the court would have residuary power under section 151 CPC to uh, to take into consideration the subsequent event. Full stop. Next paragraph. The court would like to mention herein that the no particular provision of law has been pointed out where a document which has come to the notice subsequently can be brought into record by using a particular provision in the Civil Procedure Code. Full stop. Therefore, having noticed that that a sale deed has been registered, but has not been entered into the volume books, comma, the petitioner would have a right to introduce such facts before the learned trial court. Next paragraph. It is observed from the impugn order that the learned trial court had ventured into the arena of questioning the intention of the parties or the petitioner to producing the it is a part. By observing as follows, inverted commas, in view of the above legal position relating to non-copying of the sale deed in the respective volume book maintained by the sub-registrar office and its consequent legal status of non-completion of valid sale, any reason shown by the plaintiff or any sort of evidence to that effect would be of no consequence at all. Full stop, inverted comma closed. Full stop. Therefore, the court, it appears that the learned trial court had tried to evaluate the evidentiary value of the evidence which would come on record, as if it was prejudging the standard of evidence to be led by the petitioner. Full stop. The court does not find that this is otherwise permissible in law to prejudge why an evidence is being led and then take a call whether to allow it or not. So in this case, the original sale deed was called for, volume book was produced, but the entry of the sale deed was not made in the volume book. And therefore, it is only if we accept the stand of the petitioner, the court finds that there is some relevancy of bringing to the notice of the court the subsequent event as to why the sale deed was not entered in the registration in the volume book. Full stop. Next paragraph. In view of above, the court is inclined to set aside. The court is inclined to observe that that on both the counts referred above, being a subsequent document sought to be introduced in evidence and prejudging of an evidence by the learned trial court is found to be vitiated by jurisdictional error. So therefore, the impugn order dated 9/6/2022 passed by the learned civil judge within bracket junior division number 1, Darang, Mangalde in TS 32 of 2013. It's liable to be set aside in inquest, and accordingly, the same is set aside in inquest. First of the petition number. Next para. Consequently, comma, the petition number 2533 of 2020 is 25 2553.
Yes,
Okay, 2553 of 2020 filed by the petitioner is restored to file of the learned trial court. First of the said learned court shall hear the parties afresh and pass appropriate orders thereon. Next para. The learned trial court will not be influenced by the observations made by this court in the order and would decide the petition independently. Or write to the shall independent without being influenced by this order. Next para the interim order passed earlier stands vacated. Next para both parties are represented before this court through their respective learned lawyers. First of therefore, both the appearing parties shall appear before the learned trial court on
2/2/2024, my lord, the date is fixed.
2/2 on 2/2/2024, and by producing a certified copy of the order before this court, comma, shall await instructions from the said learned court. Oh, Mrs. Chaudhary, just a moment. Oh, this is one of those cases where I was just telling few moments back that we make mistakes of not being able to sign orders and upload it. One has happened in your case. 22/12/23, we passed an order in IA Civil, sorry, MSc Appeal 164. I think you were there. Oh, no, you are not there. Mr. R.S. Chaudhary, no. Mrs. No, not you. Mr. R.S. Chaudhary, we thought it was you. No. It was not uploaded. Today was the date fixed. It was not uploaded, so we are fixing another date. If you know him, please tell him. R.S. Chaudhary.
Mrs. R.S. Chaudhary.
No, Mr. We have written. I don't know. I may have made a wrong. এটা করে দিও না বিষয় দিও তো বলবো 19 করে দিও 19 নেক্সট টাইম পাবো This was signed, but it was we couldn't upload it. Next date was today. We have to adjourn it. You can give a notice, Mr. R.S. Chaudhary. I think it will be too late. Now there will be nobody. I am the last man.
Bus driver
Oh, acha, ঠিক আছে. I'm sorry, I have to raise. Yes, Mr. Jain. Mr. Jain and Mr. Talwar, please don't take an offense. I was just, I created a lighter note in the courtroom. I was referring to you not to. It is just a slip of my tongue, but just to make it on light. I'm absolutely not making any comment on you professionally.
Item number 31.
31, yes, but I'm apologizing to you.
Item number 31, my lord. It is a MSc appeal. The respondent, I am representing respondent, she is cancer patient. So I pray earlier hearing. Because earlier I filed
Mr. Jain, I'll tell you something which has happened to in this court. Therefore, I am telling you, this all matters will be rolled over. You please make a mention on Monday or whenever you feel like to have it listed, because we will not give a date. What has happened was, if I pass an order in item 31, correct? We are not taking up item 31, but 31, if I pass an order, there may be a complaint by item number 30 saying that 31 order was passed. In my case, why no order was passed? This has happened to me.
I have some special circumstances.
No, I understand that. Please make a mention. You give a mention on Monday, courts will permit that. The reason is I am telling you because people are dissatisfied when order is passed in one matter and the earlier matter there was no order passed. So there was a genuine complaint where there's some administrative problem in passing orders in between. So all gets rolled over. Only if there is any stay order which is operating, we'll extend that stay. We are doing only that. I'm sorry, Mr. Jain, this is something which has happened and therefore we don't have to repeat that. You make a mention, we'll permit you.
Wait, please, Your Lordship, item 38, if you could extend the interim order.
38. Okay. 38.
That was for delay condemnation, first day.
Make a mention.
With your lordship, item number 35. It can maybe continue.
35. Okay. Okay, we'll do it.
Item number 50. And 51.
50 and 51. Okay. Intimate sign. At times to give what you call something I say, then I realize I made a mistake. Mr. Jain and Mr. Talagut again. No, but at times I make mistakes. I'm sorry, no intention to hurt, but it was just. It's good that you have appreciated, but regret